Judge PMLA Gurugram, Haryana, to be transferred to Special Judge PMLA Safed Court Complex, Delhi. The prosecution shall proceed at such transferee court from the stage at which it is presently pending at Gurugram.
Grateful, my lords.
Much obliged, Lord.
Lord, may I seek liberty to mention a very serious matter which has happened, Lord, very serious matter which has happened on the 11th. A member of our bar, 20 years standing, was beaten on the head and 8 stitches are on the head like this.
When?
11th. 12th, in his house. In his house. Then he lodged an FIR. Next day, again, those people came and threatened to withdraw the FIR. So, second complaint. Till date, no arrest is made. The people are going scot-free, and Lord, just see the photograph of this person, Lord. And FIR says simple hurt. FIR says, Lord, trespass, house trespass. So, I mean, if it can happen in Delhi to a Supreme Court lawyer, I don't understand, Lord, how common citizen will be, Lord, safe in this city. So, this writ was filed yesterday. I am requesting your lordships to take it on board and, Lord, call them immediately. And because this is something which can, if a common citizen, just Lord, see the plight of a common citizen, if this can happen to somebody, and the FIR records, Lord, that profession.
I join the concerns in this.
Mr. Attorney, we'll seek your intervention and assistance.
Let me. We'll also formally issue notice. It's a very serious matter.
When you were mentioning SLP number so and so.
Read petition.
Petition so and so taken on board. Attorney General for India is present in court. On our request, he enters appearance. That is status report with respect to the ongoing investigation as well as the action, if any, taken on the second complaint made by the victim, threat extended to him for withdrawal of the first FIR, be also filed by a police officer not below the rank of Deputy Commissioner of Police. Post thereafter.
Lord, in the meantime, he should be given, because they have threatened him to withdraw the FIR.
Police protection.
They came second time next day to ask him to please withdraw, otherwise you will face dire consequences.
Police protection means.
Meanwhile, it will be ensured that no harm is caused to the life and liberty of the victim. That's also. The petition is by him or by SCBA?
By him. No, it's by him. SCB has passed a resolution, but this petition is by him.
Just only for nomenclature, so shall be cast to the petitioner. He is the petitioner.
He is the petitioner. So it can be drafted tomorrow. So that
Lordship.
Yeah, deeply obliged.
Your Lordship, to mention the matter. Before the Taj trapezium is converted into a suo motu writ petition, on October 2024, this court passed saying that no new industries and expansions will be permitted. State of VP has a serious concern about it. We filed an application for some modifications to the order. That is, the application will be set at an early point of time. So unless you Lordship, I've taken the consent of the learned amicus.
Lots of various issues. There's a vision document, lines with respect to industries. All of those could be listed, my lords.
So far as Taj trapezium, yesterday there was a matter bringing it to our notice that there are green category industries. They are also being
That's right, my lords.
permitted to function.
Therefore, there is a vision document, emission. There are
IA at the behest of the union and the state, we have directed listing together.
my lords. So whenever
Lordship's order converting into a suo motu petition. I know.
yes, my lords, March 2026 order.
Your Lordship.
Maybe next Wednesday.
In any day, as early as possible, because I think we are completely bound by the direction Your Lordship said in the suo motu writ petition. All directions will be binding on us. So we need some
Thursday.
Tomorrow or next Wednesday.
Thursday.
Be next
Thursday.
There are CEC reports concerning it. All of it, I will give the list. All of those could be
So next Wednesday.
holistic picture.
Next Wednesday, Mr. Kapoor.
Thursday? Could it be on Thursday, Your Lordship? Subject to Lordship convene. Or next week.
Next week.
Or next week, whichever day is convenient.
Next week. It's next.
Any day we can fix, because there is already special bench constituted.
Lordship, please.
Wednesday is the special.
Further, if Davis may be allowed some brief, some issues that may be allowed.
Very well. May also be permitted to place,
Time.
may also be permitted to place and record a note why we have filed the IE, or kindly give us the permission.
It's all right.
Very.
With my lord's kind permission, my lord, there is an application for intervention in tomorrow's matter relating to the Bar Council reservation for women. It concerns co-option. My lord's order is there of 6th of February, which said no intervention applications till elections are over. Elections got over to the Maharashtra and Goa Bar Council on 6th of this month.
All interveners,
All notification of the results, please.
all interveners are permitted to argue tomorrow. Those who want to create chaos, everybody is permitted. You please do.
Please, my lord, I will do that, my lord, but my lord,
Let's
allow me to file that intervention application.
No, there is no need of any application. You can argue by your sisters.
Very well, my lord. I leave it to them.
Your Lordship,
Lordship,
please
the Taj
mention
matter.
It was, so this matter is being mentioned consistently for last 8 months. However, we are following, even after following up with the registry, we are getting the one statement that special bench needs to be constituted, and there is a direction for special bench, but that bench is yet not constituted, Your Lordship.
Which matter, madam?
So it is Samaj Parivartan versus State of Karnataka, the mining matter.
We will list it, don't worry.
Your Lordship, I'm mentioning one matter for
Maybe fixed for that, Your Lordship.
mentioning one matter with regard to additional prosecutor, my lord. They have crossed the overage for Delhi High Court judiciary because last exam did not happen. So the court has declined it to one day for yesterday. I'm just requesting our SLP be listed because, my lord, the notification will get over day after, my lord. Because I was a wait list last time, my lord. I'm an advocate, additional prosecutor. Last time exam did not happen. 2024, I was in the wait list. This year the vacancy came. They said because of overage of 3 months, I'm not eligible. I'm just requesting if my SLP can be
No,
listed.
it may be for one day even.
Yes, my lord. I'm just saying some relaxation because judiciary did not do the exam last year. There was no exam of Delhi High Court Judiciary 2025. Any date, my lord, any convenient we could do.
Friday.
May I seek your lordship's leave? There's a matter coming up on your lordships on the tentative list on the 17th. I don't want it to be deleted, my lords. It's a very important matter, my lords.
On which date it is coming?
17th.
Matter, Mr. Subramanian.
My lords, it's about the Karnataka Municipal Corporation elections. The SIR is going on. We had to hold the elections by 31st of August, but all the teams are doing the SIR, my lords. So it's impossible. We are seeing just some extension, my lord.
My lords, if I may.
That's all, my lords. 17.
My lords, if I may mention a matter, I'm mentioning Civil Appeal number 6759 of 2026. It was specifically directed to be listed on 15 July, my lords. It's not showing in the list. If it could be not to be deleted and added in the supplementary list, my lords.
We will see what is the.
My lords, in the Taj matter, 27th May order is not uploaded, my lords. The tree cutting matter. In the Taj tree cutting matter, my lords, the 27th May order is not uploaded. I request the lordships.
We will upload it. Please don't dictate us like this.
No, my lords, I'm only requesting, my lords, because the projects are held up.
Please, Your Lordship, with your permission, if I may mention a matter in relation to item 42 tomorrow, which is Ashok Kumar Sharma versus Union of India in relation to the Forest Conservation Act amendments. We appear for an intervener in the matter who'd like to make submissions in relation to the Kukrel Night Safari and project.
At least I couldn't gather what you are saying.
Lordship, we are for an intervener, and after our intervention, the matter was referred to the CEC. The CEC report will be considered tomorrow. Our only request is for our application containing observations on the CEC report to be considered as well.
We will see when matter is taken up.
Lordship, the state of UPIAs are also.
Larger than, bigger than the CC report.
Your Lordship, may I mention an arbitration petition? I seek to withdraw it.
Very good. Just now allowed.
The order sheet is here, if Your Lordship may permit me to.
Mention it taken on record. This was a withdrawn.
Please, Your Lordship.
Grateful, ma'am.
Please, Your Lordship, I would like to mention anticipatory bail matter. It is regarding a public health engineer. The co-accused has been granted bail, Your Lordship, but there is an imminent danger that the department might initiate a suspension proceeding immediately.
Anticipatory bail, it has to be listed within 2 days if the defects are cured.
Lordship, the department of the petitioner.
No. Suspension has nothing to do with anticipatory bail. You are wanting stay of suspension or you are wanting anticipatory bail?
Lordship, the co-accused and everybody involved in this matter has been given a chance to put their case, and they have been
By
granted.
one line answer, please. You want anticipatory bail or you are wanting suspension to be stayed?
Anticipatory bail, Your Lordship.
Anticipatory bail.
Yes, much.
Matter is defect is cured.
Yeah, deferred risk.
How it will be listed then? Matter and
Much obliged.
list the matter.
Lordship, if I mention item number 1, in a connected matter, the date is of November, if it may be placed earlier. Item number 1, Janelle Singh. In the connected matter, Lordship has placed the date for November. But our
Item number 1 is early hearing.
early hearing.
No early hearing in court.
Lordship.
Early hearing is for us. We will see what is to be done. If we find that there is merit, the matter requires out of turn hearing, we will grant. Otherwise, no hearing in early hearing.
Lordship, in item 1 only, Lordship, I am for the state, I am supporting this one, that there is an urgency in this.
In early hearing, opposing, supporting, God knows what.
Lordship, earlier, Lordship actually allowed early hearing application on our application.
All right. Thank you very much. Thank you for your.
Lordship, we are just requesting that we detagged, Lordship. The batch is coming, so the matter is not getting listed.
Thank you. Item 7.
Please. 7, my lords, I appear for the petitioner enforcement directorate. The first respondent in item 7 stands served but is not entering appearance. This is an order challenging the grant of bail. Our anxiety is only this, that they're going to delay the trial. 45 has not been tested at the time of granting bail. In fact, they're not even entering appearance here.
What is the offense? NDPS?
Please, PMLA.
Seven point 7.1 and 2 minutes.
So only in item 7, my lords, but the prime accused is not entering appearance in item 7. And this is precisely our anxiety.
One method that you.
Yes.
1 and 7.2, my lords.
Take your mic.
Oh, yes, my lords. I'm in 7.1 and 7.2, my lords.
You are appearing for Broad Sun Commodities Private Limited.
My lords, I'm for Jindal and Baban Singh, my lords. Surinder Jindal and Baban Singh.
Subhash Prasad Yadav.
I'm appearing for item number 7. Is the first case, Subhash Prasad Yadav.
Thank you, Mike and Yadav.
Yes, no, so I'm seeking time to file counter. No, so I filed my wakalatnama just 2 days back.
What for the remaining 2 you have filed the count?
We have filed, my lords. We remained in custody for a year, my lords. And there are 17 FIRs, my lords, of the scheduled offense. The learned High Court, my lords, at that time granting bail, specifically stated, my lords, that it is not possible to get the trial concluded within the time frame. Though the public prosecutor, my lords, stated that it can be concluded in 6 to 12 months, my lords. 17 FIRs, 19 FIRs, of which 17 are still in investigation stage, my lords.
We were served immediately before the vacations. I'm only seeking some time to file counterments.
That High Court has exercised its jurisdiction, granted them bail.
I bow down, my lords.
There are 17 FIRs. investigation going on. Post grant of bail, normally we would like to interfere only in a case where there is misuse of concession. Misuse can be, suppose they now don't cooperate with you in the ongoing investigation. So we wait for some time, direct them to cooperate with the ongoing investigation on all the cases. And if you find that they are misusing this concession, we will grant you liberty to file at an appropriate petition.
My lords, may I only pass on the last two order sheets of the trial court? The accused are also seeking time repeatedly before the trial court. On the ground that the discharge application, that they're moving a discharge application that this SLP is pending.
Discharge application is what we can do because the lawyers move that application.
My lords, they are making a submission before the trial court that in the discharge ought not to be heard because this SLP is pending.
No, that SLP pendency is we can dispose of the SLP, the matter and the ground. If we find that your lawyers are adopting, because what's happening in the PLA, PMLA, NDPS in this kind of trial, the local council keep on moving one after the other application. And every application is mischievously designed. We are deliberately using this word, mischievously designed. If we find that you are indulging in this kind of thing, we will cancel the bill.
Right.
Very simple thing.
My lords, may direct them to join the trial and not take any further adjournments at the very least.
These two special petitions are directed against three. These three special petitions are directed against the order cum judgment dated 29th November 2025 passed by the single judge of the Patna High Court,
29-4,
granting regular bail to the private respondents in the cases including ECIR number ECIR/14/PT ZO/2023 lodged by Enforcement Directorate in bracket Patna Zone Office against BSCPL, BSCPL is Broad Sun Commodities Private Limited and its directors under section 3 and 4 of the PMLA 2002. The allegations pertain to generating proceeds of crime by means of illicit mining and selling of sand. The Enforcement Directorate has already filed prosecution complaint number 8/2023, which is pending before the special court in bracket PMLA Patna. Next paragraph. The report reveals that the private respondents in bracket private respondents were arrested on 3rd November 2023. All were arrested on the same date or?
All three persons were arrested on the same day, Miller. My two petitioners, respondents were arrested on the same day.
It is 9th of March.
9th of March, 24.
24th.
9th of March.
Item 7 is 9th of March, my lords.
Brackets will be named list. Next paragraph. It is true that the High Court has released the respondents on regular bail after hardly 1 year of incarceration, regardless of the fact that there are 17 matters in which the respondents have been named as accused, co-accused.
Look, I'm not an accused, Miller. The company is an accused in these matters, in these FIRs. These petitioners are not, respondents are not an accused.
Respondents are not.
The Broadson company is an accused.
My lords, I want
predicate offense, out of whom the the case under PMLA has been registered, has been lodged against the private respondent. Against the private respondents. However, the principles with respect to interference in the grant, in an order granting bail are well established. Unless the order is found to be totally perverse, contrary to law, or it becomes or it is causing impediment in the ongoing investigation, this court would be extremely reluctant to interfere with the same, merely on the ground that the High Court ought not to have exercised its discretion at an early stage. Next paragraph. In this regard, London policy for the private respondents undertake that the private respondents as well as the defense counsel will extend full cooperation to the ongoing investigation or the trial as the case may be, and there shall be no adjournment sought by them without any valid ground. Without any valid ground. So that being so, we are not inclined to interfere with the improved order of the High Court at this stage. Suffice to say that so long as the private respondents continue to cooperate with the pending proceedings for expeditious disposal of the pending proceedings, it will be difficult to infer the misuse of concession of bail. However, if it is found in future that the respondents themselves or through their local councils are misusing the concession, there shall be liberty to the petitioners to approach the High Court or this court for cancellation of bail.
I'm so grateful.
Grateful. This is what is spoken.
Yeah, please. Item 8. This is a regular bail application. I have undergone 3 years and 9 months. There are total 173 witnesses, out of which 18 have been examined. Charges were framed, my lords, in October of 24. And my lords, your lordships had earlier, in fact, the matter had come before the court. Kindly at page 166.
25.
Sorry. My lords had given a 5-pronged test which the court had to apply. Page 160. My lord, the Chief Justice has ordered page 166.
166.
Correct. I'll read the effective portion. Para 3. The impugned order passed by the High Court reveals that the High Court has dismissed the statutory appeal in terms of the reasonable discernible in paragraph 5, observing that at this stage it cannot be said that no prima facie material is available. While this may be a valid reason for the purpose of proceeding with trial, however, in our considered opinion, this would be insufficient for deciding regular bail. Now, over the page, that 4. Your lordships gave 5 factors which the High Court had to consider: gravity and nature of offence, period already spent, likelihood of tampering, stage of trial, likelihood of misuse, and concession and other family circumstances. Now look at the order, my lords, in light of your lordship's order. Kindly have that. And my lords will have page 8, para 16 straight away. Just one second.
We are at para 16.
Yes, para 16, last 4 lines, my lords. prescribed a minimum sentence of 5 years, but which may extend to life imprisonment. Neither the cognizance order nor the charge order dated have been set aside or modified by the appellate court, which prima facie establishes the commission of alleged offences by the accused. So, Mullah's first point, they say prima facie offence based on charge order. Well, based on charge order, your lordships have held, just because charges have been framed doesn't mean prima facie case exists in a UAPA cases. There are half a dozen judgments of my laws. Be that as it may, now have para 18, which is the crux of the reasoning. Although in the present case, out of 173 witness statement of 13 have been recorded, but from a material on record, it prima facie reveals that the defense counsel filed multiple applications and took adjournments many times on one pretext or the other. So that's reason one. I'll meet it. Further, in the present case, statements of protected witnesses and material witnesses are yet to be recorded. Hence, probability of tampering the evidence of protected witness and material cannot be denied. This is the sum total of the reasoning. Now, the first reasoning which is put against me is my counsels have taken adjournment. My lords will have their counter affidavit where they have annexed the entire proceeding, my lords. Your lordships will have the delay chart in the counter affidavit at running page 11. Charges were framed in October 24. After that, there have been 45 hearings. I have not taken after October 24 a single adjournment. There are 9 times the presiding officer not sat, 5 times because they have sought time. That is after charge. Before charge, yes, 4 or 5 occasions, there were cases of applications, and there was also a case of some adjournment. But for last 20 months, not a single adjournment. Despite application saying do a day-to-day hearing, the trial court says, not possible for me, I'll place that order. Kindly have this, kindly, the court master will kindly pass it to the court. In May, I moved as an accused that please have a day-to-day. Kindly have page 8 of this compilation. That's the effective portion of the order, page 8, my lords. This is a May order of this year. My lords have the bold portion at page 8. Heard, considered. The above mentioned provisions were also perused, although the legislature has mandated day-to-day hearings for every NIA case. Keeping every case pending in court for day-to-day hearing is not possible for practical purposes. In some other important cases pending in court, 1 or 2 days week has been fixed, and the court also holds jurisdiction over CBI matters in addition to NIA. Therefore, considering the facts, circumstance, and overall ground reality of the case, the application is disposed of with order the case be listed for prosecution for 2 consecutive days on a fortnightly basis as far as possible. So, when the court says, I am overwhelmed, I can't do day-to-day, this is the pace at which it is going. Practically, my laws are aware of it. My laws are also dealing with it in some other case on a larger issue. Now, kindly have page 9. This reason that page 10, that protected witnesses have not been examined, this is to the NIA's account. Kindly have this order of 11th February at page 10. The learned PP requested to summon the witnesses marked as serial number so and so in the supplementary charge sheet. In this matter, the prosecution has repeatedly requested to summon other witnesses while leaving out the key witnesses. In the humble opinion of the court, the most important witness should be summoned first in a criminal trial, therefore protected witness A. So they have been producing formal witnesses instead of protected witnesses. That's the only reason protected witnesses have only been partly examined. That too also not to my account. So procedurally, I am the one who's suffering, not because of me. That then
Protected witness.
plus there are 4 vis-a-vis me, there are 4 more who remain. Vis-a-vis me, there are 4 more who remain.
Tomorrow.
15 July.
The protected witnesses are also not produced.
I think we need to examine the protected witness first. It's apparent.
Now, in the meantime, I should be released because anyway, if they are protected witnesses, may I say this? I am not even aware of the identity. What can I do?
Can you do is for your client to decide?
Because he can't.
He cannot put the.
Because that's why they are protected. The identities are protected. The identities are protected, Milos. Therefore, Milos, I would submit whatever condition. Yes.
The stratagem has already started. Page 10, first line.
Yes.
Of the order. An application for postponement of cross-examination of witnesses. Please desist your defense lawyers from taking out these applications.
We have not taken a single adjournment. Sometimes
again, you have not appreciated what we have said.
Yes, Milos.
There is a prayer for postponing the cross-examination of the witnesses en bloc. We do not appreciate that.
Your lordships will direct completion of protected witnesses within the specific. I make one request. My laws may direct for the protected witnesses to be completed in a limited amount of time and place this matter. Don't dispose it off. Kindly place this matter after that.
Pending, it is what.
Yes.
Say, as observed by the High Court in Para 18 of the interim order,
There are total 173 witnesses, out of whom only 13 have been demonstrated.
18, as of now, 18.
Protective witnesses.
It's 19 actually.
Plus 4 vis-a-vis me, 4 vis-a-vis me.
Total 19. 4 have been examined, protected. And against him, there are 5 protected witnesses now, as of now. Only 1 has been examined. 4 are.
So 4 vis-a-vis me remain. That's what my submission was.
Out of 19, how many examined?
4 have been examined.
There are total 19 protected witnesses, out of whom 4 have already been examined. Amongst the remaining 15, almost 4 protected witnesses pertain to the allegations attributed to the petitioner. The trial is now fixed for tomorrow. We direct the prosecution to produce at least 2 protected witnesses against the petitioner tomorrow, that is so date. The trial court is directed to list the matter after 10 days. After 10 days, the remaining 2 protected witnesses, those after 10 days, the trial court will be directed to ensure that statements of all the 4 protected witnesses who are the petitioner are recorded by 31st August 2026. By 31st August 2026. Also, the Learned Senior Counsel for the petitioner assures that no adjournment shall be sought by the defense counsels for cross-examination of the witnesses. The trial court is also directed not to adjourn the case on the request of the prosecutor or the defense counsels and complete the recording of and record the statements before the witnesses as directed above within the time prescribed. Post this matter for further consideration on so date.
First week of September, my lord, your lordships are going to. Grateful to the court.
My lord, I am requesting for the passover. Requesting for the passover.
Chief's view is not at all to.
Your original target and how much you succeeded?
Sir, I don't know. Senior arguing single and arguing another court.
Target seems to be to hit many centuries.
I am requesting for the passover.
Passover or
Passover.
Huh?
Passover.
Passover.
Yes, sir.
Then you can pass on this question also. We will grant Passover, but pass on this question.
May I please, Your Lordship? Officials are pleased to issue notice on the 28th of May, 29. Pursuant to which a counter affidavit has been filed. 9 out of 46 witnesses have been examined so far, my lords.
21 cases against
All the other co-accused are on bail, my lords.
So this is the interlocutory order is challenge.
21 cases. How much time will you take in concluding trial?
Lord, before the Lord, because 9 witnesses have been
examined out of 46 note. Most of the material witnesses are there, but main things on 19 antecedents, 11 prior to the incident, serious offenses, my lord.
You can't only by making allegations of 1920 FIR, you can't convict him in advance.
My lord, here with due respect,
This is all for all intents and purposes conviction. 5 years he is in jail without any conviction.
Lord, may I submit one thing, Lord, with due respect? This is the interlocutory order, Lord, of the High Court. The bail pending before the High Court, Lord. My Lord may direct for the hearing before the High Court, Lord. And he can argue.
No,
No.
Lordship, it's coming tomorrow
No
before
decided
the
so far.
High Court. Lordship has already spent 5 years, 8 months in custody. And the third bail application before the High Court.
We instruct specially petition. Although effectively filed against an innocuous order with February 27, 2026, whereby the third bail application of the petitioner is directed to be listed before an appropriate bench. In sum and substance, the prayer sought is for expeditious disposal of the bail application filed by the petitioner and which is pending before the High Court. It may be true that the petitioner is involved in 21 cases, but the fact remains that he has already spent 5 years in custody. In light of the principles laid down by this court, it seems to us that the High Court need to decide the pending bail application in a time-bound manner. Consequently, we dispose of the special petition with a request to the High Court. With a direction to the Registrar General, Stoke Registrar in virtue of the judicial of the Allahabad High Court to list miscellaneous bail application number 7328 Stoke 2026, after obtaining necessary order from Honorable Chief Justice of the High Court, before an appropriate bench within 1 week. We request tomorrow.
Lordship's coming up tomorrow, yes.
So it is already listed. Then this part is, then say we dispose of this SLP with a request to the High Court to decide the pending bail application expeditiously and preferably within 2 weeks.
So,
Much obliged.
Please, my lords. My lords, we gave ourselves the Constitution of India on the 26th of November 1949, my lords. And the Supreme Court came into existence on the 26th of January 1950, my lords. But under Article 32, which was already made much before the Supreme Court came, my lords.
But you tell us what is the mechanism?
Is the mechanism, my lords.
This,
What happens?
I also
Practically what happens, my lords, unfortunately, is morning 10 o'clock, I make a petition, I bring it before the registry. The registry will go through it. Now, my urgency came much before 10 o'clock in the morning, but I have to wait for that urgency to be addressed before the court. It goes before the registry, and thereafter the petition comes before the court.
So problem is that, you see, I don't say that it's a regular practice, but it is oftenly seen that how incomplete and vague paper books are being filed.
True.
Yesterday only probably I have approved an administrative order requesting the advocates on record that please when you file the case, at least this much you will disclosed in the petition. Name of the parties, the nature of the relief you are asking for, the bare facts, question of law, and prayer clause, along with some documents at least. What's happening is you find suddenly you find a paper book of 100 pages, but only 3 pages are typed one. All remaining 97 pages are photostat copies of some documents, some photographs, some Google map, this and that. No head, no tail. How to list those matters on the same day? That is a challenge.
My lords, those may be technical. Here, what I have brought before my lords is when there is life and liberty in question.
We agree with you. Speaking, I think none of us will quarrel this proposition that these matters should be heard immediately, and particularly the matters relating to liberty. But then you have to tell the mechanism also.
My lords, I'll help my lords with the mechanism, my lords. It is there, my lords. If I file something after 6 o'clock in the evening, my lords, for a very urgent thing, I cannot access somebody unless next day morning my clerk is there, my lords, in the registry telling them to please clear it off. Think about a litigant who comes to the court without to 4, subclause 4 for a moment with me, my lords. May I read, my lords? Guaranteed by this article shall not be suspended.
In fact,
my lords,
emboldened by the prayer or the request from the bar, and during this partial working day, I constituted 5 benches for every week.
For which we are grateful.
We kept on waiting for the lawyers to come. The adjournment slips, the adjournment circular were more than the members of the bar.
Unfortunate for that, my lords. But my grievance is not there, my lords. My grievance is this: if I am a poor man, my lords, I want to have access to justice, my lords. I can only access a legal aid committee during the day, my lords, not at night, my lords. I can access the court only in the day, not at night, my lords, when it is very crucial for me to appear before the courts, when it's very crucial for me to see the court.
Is it unknown that there are hearings in this court?
My lords, does it happen? Does it happen for every litigant who has that urgency? It only happens
That is
to
the
those.
question, madam.
My lords.
What you want to change?
My lords.
Official hours and unofficial hours should become same. We do not agree to that.
I understand.
There is
I understand
difference
false,
between
my lords.
access to justice during official hours. There is a difference, and a different criteria is proposed to access to justice beyond official hours. If that was not there, your case is made out of non-access. But a graded access to justice is not a denial of justice.
My lords.
Reflect on it, come back, consider it.
Do one thing, I will permit you to interact with the registrar, to enter whichever branch you want to go and visit.
My lords.
And give us some concrete suggestions. Give us a SOP.
Very well, my lords.
What is the standard procedure that can be followed after the court hours, which according to will ensure access to justice? We have no difficulty in introducing that.
I'll do that. I'll do that.
Because I recollect on 15th November, before I took over, I made an appeal to the High Court that you please start working 24/7 like government hospitals. So if I can request the High Court, why not the Supreme Court?
Grateful, my lords.
But tell us what is the standard procedure, because mere announcement is not going to serve any purpose.
I understand.
Even if we make a commitment,
I
unless
understand.
it is actually implemented at the ground level.
May I just at this juncture share a personal experience, my lords? There is this couple who had reached out to me late in the evening just to convey to me that we have gotten married. It's an inter-religion marriage. I have not placed it before in the record minutes. This is around 8 o'clock in the night. They say we have gone to the police station. We have told the police wala that give us protection. I am a Hindu, I am a Muslim. We have gotten married. We are in love. The police wala makes them sit in the thana. At 11:30 in the night, the parents of the girl are called and the girl is handed over to the parents, not in the police station. Rather, she's taken all the way near Maulana Abdul Hospital, and just outside the gate, she's handed over. Now, this boy who had just gotten married to the love of his life was following the vehicle just to see that everything is going right. He goes into full-blown panic because his now wife has been given over to the father who may do something out of honor. In that situation, what does he do? Where does he go? Should he go back to the police wala? Because the police wala is the one who has handed over, so he doesn't trust that person anymore. He reaches out to us. Now it's already beyond 11 o'clock, 12 o'clock. This is 25th of December, 2025, if I'm right, my lords. 2005. I look for everything. I've been practicing for 18 years now, my lords. I look for everything. A quick access. How can I get a quick access? How can I make this client get access to justice very immediately? Because the urgency is now, if the girl dies, if something happens, then what? My lords, till 3 o'clock in the morning, I have tried knocking at every judge's door, whether it's the Honorable High Court's Chief Justice, whether it was my lord's residence door. I couldn't get access. That is when I am a lawyer, my lords, for 18 years. Imagine the pay of a...
That was 2005.
2025, my lords.
25.
Yes, my lords.
You didn't get access to the registrars of this?
No, my lords. The one whom I spoke to, madam, please wait for the morning. Now, morning, what do I do, my lords?
That's a wrong
Do I bring that dead body
There's
and
a
then...
difference. There's a difference. This is a wrong decision, maybe in the facts.
My lords.
But it doesn't mean that you did not have access. You had access. The assessment of urgency, great.
There has to be a mechanism in such
This
emergency.
can wait till morning. You may agree, you may not agree with that. But you are absolutely right. If there is all those clauses, and which was when we didn't have digital filing, digital access, there's a question of complete closure to access. But here you have the online filings. And forget about a lawyer. A letter written has an access.
Yes.
And if a mobile phone call or email to a concerned registrar will be responded. Now, if there is a lack of response time, yes, that as we are proposing, we can have a SOP.
Yes.
That if an urgent communication is made, the institution is duty bound to respond within, let us say, an hour.
That's my only prayer, my lords.
That is possible, but where the court is going to open its doors and whether it is during unofficial hours, it would be required. That has to be said.
Very well, my lords. So grateful, my lords.
One of the way out can be that all the high courts, they can have a display board, online display board,
Yes.
where the lawyers can lodge the urgency claim. People will lodge lot of frivolous claim also. For them, a partition dispute will also be a very urgent matter which requires midnight hearing.
Right.
But then there can be some mechanism either based upon some a registrar, some judicial officer can in the night examine that is there an actual urgency.
Right, my
And if that, then there can be some process for listing of the matter.
My lords.
Yeah.
Some suggestions.
Very well.
To issue notice to the high courts.
I'm grateful, my lords.
The history of this court for the limited purpose of inviting suggestions
For formulating an SOP.
for formulation of SOP, SOP with regard to listing of
Would it
extraordinary.
if your lordships on the administrative side considers this? I don't think, my lord, every high, that's my respectful view, my lord, subject to your lordship's approval.
Solicitor, our view is once the online filing and access is available, can't we say that the court's doors are closed? There may be a differential response on the expectation of a litigant and the assessment of the urgency.
Because my worry is,
there can be a
my lord,
gap
intentions are not clear. But my worry is, suppose, my lord, I move at 10:30 tomorrow, saying that tomorrow there is a meeting of COC at 9 o'clock, and therefore permit me to circulate the matter at 12 o'clock midnight. It would be an urgency. It would be very difficult to bifurcate. But some SOP or lordships on the administrative side can devise.
For Supreme Court, we can. Problem is only for high courts, it may not be appropriate for us to issue.
My lord, in this order itself, requested, my lord, to devise the SOP. That's my respectful. I have no, my lord, list in the matter.
Yeah, absolutely right. You're absolutely. There are genuine, there are contrived situations of urgency.
Lord, I have requested, my lord, High Court, my lord, many times.
Much earlier. And as the solicitor says, at midnight the application is filed so that an ex parte order can be obtained.
Yes, and generally, my lord, if there is a genuine urgency.
So this kind of procedure is capable of misuse also. It can be prone to misuse also, no doubt about it. And
but
or such procedure can be confined only to matters pertaining to life and liberty. That's what.
Yes. And my lord, whenever your lordships can, in a judicial order, my lord, subject to your lordship's approval, request the high courts that keeping these factors in mind to develop their own, my lord, state-specific or high court-specific SOPs, rather than, my lord, bringing everything here. It might be counterproductive, my lord, 30 lawyers appearing and assisting a lot.
We can do that also.
Grateful, my lords.
Obliged.
Grateful, my lords.
Lord, at the outset, Lord, I am conscious of one fact against me, my Lord, and that is, my Lord, perhaps fatal. Lord, that is, Lord, the consent given. Consent is recorded. But I have a request for another request. Consent is recorded. Whether, my lord, under what circumstances, etc., I cannot argue that here. Lord, the question is, if your lordship only sees at page 227, my case was that section 11 is premature in the sense that under the contractual provisions, there is one stage of third-party quality auditing, which had not taken place. And 227. Circumstances is, if your lordships can, my lord, request the learned arbitrator under section 16 subsection 5, there is a statutory mandate that question of the arbitrability and jurisdiction will have to be decided first. If it can be requested, my lord, that may be decided first.
May I only submit this, my lord? This is an order of 14th August 2025. After that, my lord, the arbitrator has had 5 procedural hearings. Parties have filed their statement of claim and statement of defense. I have also filed my evidence. It was not, they delayed in filing their evidence.
That's correct, my lord.
I'm not. Section 16 has to be filed at or before the filing of the statement of defense. And I'm not standing on any formality or technicality. 14th August 2025 is the learned High Court's order. 1 year, my lord. And the arbitrator gave them repeated extensions to file statement of defense. They were delinquent, but they finally filed. They have not filed evidence, my lord, in time. Yesterday, my lord, the honorable arbitrator gave them time till August. Lord, even this SLP,
my lord, my 16.5 application will have to be decided. That's all.
Your lordships are aware, even the arbitration is time bound in 12 months. In 12 months, my lord, we have not even started evidence for no
12
fault
months
of the
after
claimant.
completion of
And
period.
Lord, I'm not. High Court also, my lord, the appointment was not made on day one. My lord, High Court, my lord, the same council appeared in May, appeared subsequently, and thereafter, my lord, on 14th August 2025, gave consent. Lord, whatever defenses they taken,
whatever arguments are available to them.
Yes.
You see, that was they are entitled to raise.
Lord,
Yes,
appreciate,
they
Lord, I'm
can
only
raise
standing on this,
these
Lord,
very
your
arguments
lordships
before
have
the.
said repeatedly, my lord, court interference in arbitration proceedings. My lord, if your lordships observe something, as this honorable court, your lordship knows what weight it carries. My lord, this is an arbitration. It has gone in a certain procedure, my lord. My lord, it has kindly see, my lord, this.
Grant the liberty to the parties to raise before the learned arbitrator. Learned arbitrator will decide as per law. We are not asking.
Yeah. My lord, if your lordship will clarify that, my lord, not give liberty to file a section 16 at this stage. My lord, because whatever they have, they can
raise maintainability issue before them.
No, my lord, if your lordship observes that a 16 can be filed, then my lord, that may not be able.
We are only saying that we say Learned Solicitor of India on behalf of the petition board and Ms. Niti Learned Senior Counsel on behalf of the respondent who is in caveat. Delay condone. Can say whatever contentions are so to be raised. And Hers one so the issue of jurisdiction of the learned arbitrator may be raised and be decided in accordance by the learned arbitrator in accordance with law.
With law.
Yes, we do not express any opinion in this regard.
My lord, may be raised if available, your lordship will say, my lord.
That's why in accordance with law, Mr. Rai.
My lord, your lordship is giving them liberty to raise it at this stage that. My lord,
both sides.
I'm only saying.
Former Supreme Court
Yes.
Right. The question is arbitrability irrespective of 16.5 can be raised during the hearing itself.
I would really submit
Perhaps only.
But your lordships are protected after
It cannot be done pre or post award. That's the problem.
Two contentions are kept open, are left open for both sides.
Please, oblige.
They should not come within the time. It's against.
With respect, when I. Can I, my lord?
Yes, yes, sir.
My lord, this SLP
is rights to know of 7 crore people in Tamil Nadu. I am Vijay Pandian, appearing 14 persons in this SLP, diary number 21411
All
of
of you have
2026.
elected a new government in Tamil Nadu.
Yeah.
Go and make an appeal to the government. They will install all TV channels, whatever you are wanting.
Absence of the district revenue information channels in Tamil Nadu, totally. So, we don't get any
Tamil Nadu is
information
not a
about the
state.
government schemes, but anything, and no one there to question.
First of all, we do not underestimate your state. According to us, your state is very vibrant state. Even without TV channel, Tamil people, they know, they are very well versed about what's happening in and around. Very educated people and very learned people.
Sir, people's not having the awareness about the media power, sir. State has a surrender to the political parties. Only they are using the political propaganda.
Policy matter, Mr. Pandian. That
This is not a policy matter, sir. This is a fundamental rights of Article 19, subclass 1A and Article 21, sir.
Today you don't require news channel. There is all social media influencer channels.
Sir, RTA sections 4 clearly said suo moto disclosures is a state duty. State failed past from 12 years. So without the basic structure, when failed, RTA never useful, helpful for 7 crore people, sir.
The foundation.
Social media, we want, sir, the High Court order only clearly said there is no guarantee for the fundamental rights.
It goes for news in print or electronic media.
One second.
Social media.
My lord,
Influencer.
my lord, the High Court itself clearly said there is no guarantee for the fundamental rights of Article 19, subclass 1A, which is expressions under Article 21. Clearly, you can see the page number 35. The High Court only said because of the none of district medias, there is no media awareness about the Tamil Nadu peoples. The political parties or the cinema guys only teaching the political propaganda and cinema stories. No one is there to question. Even ruling party can't success without the corruption from the government side. This is the no one having the knowledge. Even Tamil, the name of people are blaming, kept as a slave. Today I am as educated. Tamil Nadu is my 4th state and 5th language. I raised by nearby states. I can understand constitution of the 3 assembly, how far functioning inside the Tamil Nadu. So that's why bravely I came here. I approached the High Court. Even a High Court judges not having the awareness about this because nothing in the syllabus law books about the medias. Practically there are the district medias. Today the state has schedules under the corruptions because of the medias. Wherever the media's function is good, there will be the corruption less. Wherever the media's function is not bad, there will be the corruption is high because of the Media Act. Media Act. That will be amendment in next case. But before that, I am requesting the emergency that the state machinery is using for the elections by a ruling party. There will be held, opposite party will be held by the police. So there is no equality, Article 14. So requesting my lordships to issue notice and interim directions to.
Are you a practicing advocate?
Yeah.
Oh, very good. Why is such a arguing?
Sir, I am telling everyone, I raised nearby states, but no one can understanding what I am saying. No one having the knowledge about that. Even not having the books, we are having the syllabuses.
Forget about this TV channel. You think of shifting to Supreme Court your practice.
Sure. After complete whatever I have to complete the Tamil Nadu disputes, sure, I will be step into the Supreme Court. Sure. Sir, this is 7 crore people of fundamental rights. Sir.
You have to now consider 2 things very seriously. One is, if you want to continue in practice, then you can think of shifting to Supreme Court. You can argue very ably some matter. Second thing, now the new election must encourage you. You can also form a political party and contest the next election there in this state. And your agenda can be that if you are you are brought in power, you will provide every new TV channel in every district or maybe in every taluk level.
So if I have the opportunity, I will be doing for my peoples. I am ready to do for my people's injustice. I am requesting to interim order to telecast district revenue display board and appoint the nodal officers in district wise. That's all, my lord. Otherwise, we are not having the police and take anyone under any sections. No one can questions. Even the state media channels also political propaganda. They are in favor to the police and governments. Whatever they are writing the FIR, they are telecasting as a news. That's all.
Since the creation of, we have heard the petitioner in person at a considerable length. since the creation of district media revenue channels essentially involves a policy decision, more so when it has financial implications, we are satisfied that the issue does not fall within the domain of the judicial review. The petitioner, if so advised, may pursue the matter with the
Completed political exam.
with the competent. Thank you, Mr. Pramdan.
Thank you.
This is to be disposed of in reference to both the orders. There can be 15, 16 orders also.
This will be called by 10th April.
April, read with 4th May amendment. Because there can be some years.
So last time we passed a composite order that will take.
Same order may be passed. This is the 4th May order.
All right, dispose.
Obliged.
Updating of biomedical waste from
Your Lordship, my lord, I understand as your officer, some connected matter may have got dismissed in this. My only grievance.
So you see, in these matters, we will only tell them that now this time they should remain strict to comply with the time.
That's what I was trying to bring to your Lordship's kind notice. 23, it was categorically stated, we will take strict action if nothing is done. Again, they have been given that long rope. My lord, thousands of people, and these are biomedical waste. Every day, black fume is coming out. Children are suffering. The medical report given by
the council, you can always approach the High Court.
My lord.
Seek a review or a modification of this order.
My lord.
By praying that the High Court monitors the development so that it is done within the time frame which is proposed.
My lord, I fully appreciate that. My lord, actually, there was a similar matter here. Your Lordships helped us in Dehradun.
However, approach the High Court. Of our order.
My lord.
Exactly. ये ना इसमें अबू वसीम वाला
हाँ अबू वसीम correct
25 passed in SLP diary number 67005/2025, which was filed against the same impugned order. We are not inclined to entertain the special petition. The same is accordingly dismissed. However, this order will not preclude the petitioner from approaching the High Court with a prayer to monitor the development of waste treatment facility project within the biomedical facility within the extended period.
I'm deeply obliged, grateful, man. Deep.
Make this much. Item 16. 16, Malot, statutory appeal.
ये हो गया पहले कोर्ट वाला सेकंड
It's a statutory appeal, my lords, against the order of the NGT. Now, the NGT in this matter, my lords, has carried out absolutely no adjudication.
Mike.
I'm sorry. This one. Right.
The
mics are switched on, my lords. All the three mics are switched on. I'll be louder, my lords. I'm sorry. So, against the NGT's order, statutory appeal. The NGT in its adjudication, my lords.
But now it is CRZ2.
No, regardless of that, the requirement, regardless of a CRZ2 or a CRZ1.
Earlier MZCA permission on 2008.
Now that can't come in my way.
The extension to 7th and 8th floor. Why?
Correct. So that cannot come in my way for this one simple principle. Please have page 2 of the impugned order. I have raised 2 categorical grounds that there was a requirement which continues as on date under the statutory regime that you have to have a MOEF clearance. That MOEF clearance for any project that you undertake beyond a 5 crore project amount has to be sought as a precondition. Please have page 2 of the impugned order. About 10 lines from the bottom, your lordships will see that my first grievance was this, that this is a heritage building. Now, please have about 10 lines from the bottom in paragraph 3. The project proponent demolished a heritage structure without taking a mandatory prior environmental clearance from the MOA.
For putting the hands of the clock back.
No, I'm not doing that. I'm not doing that. Your lordships will just allow me to.
Structure was in 2004.
Allow me to show that. Now, I just wanted to see. Now, please have the next page 3 at the top. This is why I wanted your lordships to see this. Please have page 3, top. The total investment for the project. In that approach, please have, my lords, for a moment, page 3. I just want to show that I've raised this. The requirement of the statutory notification says you have to have it even now. The second line from the top, a total investment for the project, including the land cost, was more than 5 crores. Please, my lord.
Filing against an individual sometime
that has not been found against me. I appreciate what is falling. I appreciate. Correct. Now, my lords, only because this gentleman is a film star, it doesn't mean, my lords, that the laws will not apply. The laws are going to apply squarely to all and every.
We are no way influenced either.
I am very grateful. I am very grateful, but I cannot say the same. I cannot say the same about the impunity.
Might have been absolutely right.
Please,
if you were there before a form,
please,
in 2004, 5 when all these violations were happening.
Well, may I respond back to that? Well, I appreciate, and I therefore, Malords, went into the credentials of the petitioner also, everything, although I've not even been non-suited on locus, etc. Leaving that aside, today's issue is this, Malords, that this is a continuing wrong and it will not be ratified by passage of time. Now, please see, I just wanted to show those provisions. Please have the notification at 142, and the relevant part is the updated part is at 147. 147 says that not only demolition, but also reconstruction. What is now going on is a further construction of 2 floors. Please have 147. You have to have a prior MOEF clearance, 147 serial number 4. This is a regulated activity under the CRZ area. 140 number 1. This is reconstruction of a heritage building, and please have serial number 5 for a moment. All other activities with investment of 5 crore rupees or more. And I raise this not only in my appeal before the NGT, I also argue this.
But can of NGT clearly answer this question?
I'm sorry, Malords? No, Malords, it doesn't with respect. Please have, Malords, the NGT's order. With respect, Malords, please have page 4 for a moment. I want to show the manner of adjudication and how this is perverse on the face of it. Paragraphs 5, 6, 7, and 8. Are a mere reproduction of the impugned clearance that has been given to them, which I have challenged. And then after that, in paragraph 9, the NGT says that please show me some procedural error. Now, I have already shown the NGT, my lords, which is recorded by the NGT and also as part of my appeal before the NGT, that see, there are procedural, that there are substantive violations. I have filed these notifications. Now, please see in what manner.
So, if someone is exploiting a property for the commercial gains for anything, they are living there, the residential house, they want to have it, their choice. Law is broadly being followed. Why one's neighbor or anybody else?
No broad following of the law is my request. And my lords, I only wanted the NGT to examine all of this. Your lordships may remand it back to the NGT to see all of these substantive questions. So, my lords, this impression should not go, my lords, that there is a separate law for the high, mighty, and the influential. And this is a case of that nature. The High Court, my lords, the NGT places it on me to show where is a procedural violation.
It is an otherwise case. At this stage, somebody is entertaining, somebody is filing this kind of petition. That sends the wrong signal that he has some reason X to grind or.
With the greatest respect, my lords, this is a very seasoned, respected environmental activist. The other scam, he was a petitioner in that, my lords, after which, my lords, several actions have been taken. The Sanjay Gandhi National Park reservation, he was part of it. The Lavasa case, my lords, he was part of it. He's a very seasoned, bona fide environmental activist. It can't be, my lords, that everybody is painted in the same paintbrush. And here is a case where the approach of the NGT, my lords, is completely perverse. To the extent, my lords, that everything that I've argued has been noted, no adjudication, not a single point has been dealt with. And the NGT, my lords, procedural violation. If I am showing, my lords, that there is a collusion between the authorities or there is a failure on part of the authorities to come forward and address all of these substantive violations, my lords, it was upon the NGT to at least have issued notice. I have, my lords, substantiated a prima facie case at least for a
what occurred in the grant of
earlier.
clearance
Correct.
in 2008
Correct.
for NGT
Correct.
can't be reopened.
I am not even asking for that. Please appreciate what I am submitting.
Reopened because of the limitation clause.
Very well, no problem.
Right.
Let's, I'll leave it there.
Now, so what goes is
Correct.
2004
Please, my lord.
conversion
Please.
of art gallery.
Right.
What goes is the building of the ground, digging of the ground for building a swimming pool.
I am giving a go-by to everything. I'm only sticking to one thing. Please.
In the inquiry is the permission to build on the over and above 6th and 7th.
Well, even for that.
In the respect of land use or FSA available to the owner of the.
Please appreciate that the environmental clearance is as much a statutory mandatory requirement. That's what I am saying, that the MOEF should have granted this because this was a project in excess of 5 crores. I have stated that. This is what page 147 is saying. It says that all other activities with investment of 5 crore rupees or more MOEF clearance will have to be given. That clearance is not given. I have raised this ground. This is, my lords, in my respectful submission, sufficient for the court, the NGT to have, my lords, which is again a statutory tribunal bound by all requirements of law, to have gone forward and issued notice.
Understanding is your argument was since these are errors, they ought to have been corrected. Otherwise, the 2025.
I am giving up every violation. Please appreciate. I am not on that. With the greatest respect, I appreciate. I am not pressing that, my lord.
NGT can only be in respect of things which are within 90 days.
I am grateful. Now, my lords, what has happened is this: that what happened is that on 5th of March 25, my lords, there is an order which has been annexed. The NGT says that between 2005, 2008, etc., nothing can be gone into. You amend your petition, come back, and litigation of 3/1/25. I am only restricting it to that. I am not going beyond that. All of these submissions, my lords, were please have that order. 41. Please have 41.
See your submissions in.
Well, lords, that's wrongly.
In
please
page
see.
3.
Very well. Please have 41 for a moment.
What is the violation?
Please have.
That's it to landward side development.
That is not my submission. That I am not pressing any of that.
Sure.
Lords, please allow me to, lords, I am not pressing any of that. And that has already concluded by page number 41, 42. I am not even raising that. Lords, I am not raising that. With the greatest respect, environment is kept aside. I am not on that. Please have 147 for a moment. There,
yes, what is
for a further reconstruction. This is the MOEF notification. Starts
that is an incorrect understanding.
No, my lords, that is not even my case. The NGT does not even say that themselves. Please have 142.
CC 147, sir.
142. Now, please have 146 for a moment.
Yes.
Please have 146. Regardless of CRZ 1, 2, 3, any CRZ, 146 for a moment. Serial number 3, at the top of the page, regulation of permissible activities, all activities, and please have serial number 2. The following activities will require environmental clearance from the Ministry of Environment and Forest, Government of India, namely, now please flip over to the next page, my lord, serial number 4, about 10 lines from the top.
Is there a heritage building when the permission?
I am not even pressing that. I am not even.
You are resurrecting a heritage building.
Your lordships are misunderstanding me. I'm not even saying that. Let me state it for the record. I am saying only one thing. Please have serial number 5. All other activities with investment of 5 crore rupees or more. I am pinning myself only to that, my lords. Let me make myself clear. I am not on any heritage building or on any demolition or any previous.
Honestly speaking, at least I have very serious doubt on it bona fide.
Malords, that is not even a finding of the NGT, Malords. That is not even held up against me. Malords, therefore, that's what I'm saying. Malords, that's a wrong impression, Malords. I have not even challenged all of that. I am not pressing any of this. I am only on one thing. Please have. Your lordships asked me, my lord, where is that? I am only pressing serial number. I have raised.
Page 147 applies only in case of buildings of archaeological or historical.
No, my lords, it doesn't. With the greatest respect, it doesn't. It doesn't. It doesn't. With the greatest respect, it doesn't. My lords, please have serial number 3. I'll start from the start. 146, serial number 3, serial number 2 now. After that.
5 crores.
That is the one in my favor. That is the one in my favor. I have raised it in my appeal. I've argued it. He has noted it. He should have dealt with it.
Is it a disclosure before MZCA that this building, that the...
I'm very grateful. Nothing is recorded. I am saying categorically that this is 5 crores. It was their duty to have examined. They should have 7. Please appreciate. Please appreciate. The authority which is granting this clearance has to mention that this is under 5 crores. Therefore, there is no MOEF. It can't be, my lords, anybody coming around and saying that, no, you have not done this. You have not done your job. The requirement and the onus was strictly, my lords, on the authority, the CRZ authority. And please see the notification, the clearance. The clearance does not record that. Please have 111 for a moment. This is the clearance.
Is going on.
My lords, your lordships may at least demand it back, my lords, for purposes of substantive adjudication. My lords asked me, my lords, where is this missing? I am not even pressing on something earlier, my lords. I am pressing on this which is existing. Lords,
but once we have a doubt on the bona fides, we should not.
My lords, your lordships may not. I will come back with the bona fides, my lords. If your lordships want, my lords, I can come back. This is a very respected environmentalist, my lords, as your lordships praise. There was some delay, my lords. Your lordships may condone that. Grateful. Some face saving at least at the end of the day. Grateful, my lords.
Yes, item 7.
Would your lordships please turn to page 177, please? And I'm hoping that your lordships are able to expand it. Just
you are coming at what stage?
My lord, as soon as I got my response from RTI, which was the only way I could have even learned of anything amiss, I have approached the court. So there's been no delay on my part. But my lord, this is quite serious what has happened here, because there are 2 or 3 things I'm going to point out. My lords, what has happened is that on the pretext of moderation, these marks have been deducted. There is a clear interpolation at 177, your lordships will note, and it is only in one paper out of 4 that I took, and from serial number 18 to 22, only 4 questions which are successive in nature. There's one after the other, those questions, and in each one of them, your lordships can see the interpolation has been taken place by hand. So, and what is also very interesting, and it's so remarkable, that the number of marks which stand reduced by this interpolation is exactly what is required to knock me out of the cutoff. So exactly enough. I'm sorry, my lord, I
was just trying to ask, you were called for interview after the main results were also announced.
Yes, I was called, but then
your marks were already done.
My marks?
Yes, the moderation didn't happen after the interview.
The total was there, but my lord, I didn't make it for the cutoff because of this.
After the interview, not after the moderation was done. You were preliminary, and then mains were done. Your paper was corrected, you became eligible for the interview.
Yes.
After the interview only, till then you also did not challenge anything. Interview, you were called. After that, you were not selected.
Included the mains as well as the interview. So, but the RTI query, which I find, that's the only, this is my only access. It was through RTI. This is what came to me through RTI. And what I saw is this interpolation by hand. Now, Malad, if it is a case of moderation and Malad, by a head examiner, as they now claim, then surely, Malad, because I understand that the examiners themselves were of the rank.
The point is that at what stage and how did you got this?
Malad, RTI, I made an application.
RTI, when did you
Before the
apply?
training. Before the training started, I made my application under RTI on 5/6/2020, and I'm sorry.
The writ was also filed.
The writ was also filed, my lords, in 2020 itself.
I was supposed to be interviewed because I'm doing marks, but the total will be the marks and the mains, the marks.
Few points which your lordships may note from 177. If this is done by a head examiner.
177 is fine. At what stage you came to know what prevented you to apply under RTI at the earliest when you had some?
I had applied at the earliest.
My lord, I applied on 5/6/2020 and I got my notice of results on 19/11/2019. So, my lords, it was very proximate that I made my application.
When did you approach the High Court?
Writ petition is filed, exact date I'll give up the writ petition.
Writ petition is on, writ petition is filed September
2020.
And the office.
My lord, I think if just for a moment, my lord, it's a writ. So, my lord, delay by itself. My lord, assuming against myself, I assume. But my lord, there are 2 or 3 points I want to just highlight from this page 177. Number one, if this is done, this kind of interpolation, which seems to me very odd that a head examiner who would perhaps be higher in ranking to even a district judge, because I understand that the examiners were district judges. So obviously somebody higher than that was the head examiner. Well, it's very difficult to believe that a head examiner of that ranking would overwrite marks like that. He would probably, if it was required, he would have probably in a separate column or something initialed it at least that this is legitimately done for reasons of moderation. Number one. Number two, how is it? I ask myself the question. I take 4 papers. Out of that, in only one are this moderation done. Number 3, those questions are bunched up only 18 to 22 and the marks deducted add up to exactly what is required to knock me out of the race. So it is all a little remarkable that this happens. Malad, they do not disclose the policy. They are asked by the High Court, what is your policy? What are your norms? No disclosure.
Not exactly.
I'm sorry.
The deductions are substantially lower than the cutoff by 4.
No. Total, my lords, comes to 7 marks. 7 marks
is now 147.
So, my lords, if you did not deduct these marks, I would have made it.
We are in with you, but not that they're just arithmetically.
The deduction is enough to knock me out. If the deduction wasn't there, I would have been in the race.
Now the thing is,
So, my lord, that
how a moderator is going to make the corrections. It's
Yes.
a subjective decision of the moderator. There is no rule prescribed.
that is, and my lord, there's no, I am doubtful as to whether a head examiner has done this.
There is no allegation of malafide.
There is no allegation of
My lord, when there is interpolation, my lord, please see this. These are careers of young people. This happens to be a young woman who, my lord, she's a first generation, so it's not going to be easy for her to make her life in the law. But therefore, she has sat this exam. She finds, my lord, it's very difficult to make an allegation like that of malafide because you know who's checking the paper. But this
of our jurisdiction. We cannot bring it in through the back door of suspicion or hunches.
My lord, just on the face of it. Should somebody's
Presumption of bias
My lord,
against authority.
my lord, should somebody's marks be tinkered like this on the basis of overwriting? If it is moderation, please do it properly with an initial.
Exactly where if a moderator had been prescribed that he will have a separate sheet and your marks could be.
I ask myself, my lords, we are.
Understood that in judicial review, the processual justice would enable us to take a peep into it.
My lord, this is so,
how can a moderator,
with great respect, my lord, this is so cavalierly done because I mean, I find it difficult to fathom that any head examiner of that caliber, my lords, would do this. Number one, my lords, please see, they were asked, please disclose your policy. There are no norms disclosed because I ask myself the question, if I have not met with a certain, my lords, say a prescribed norm, I have not written my answers. Surely that would, my lord, pervade the entire answer sheet broadly. How is it that only question number 18 to 22, very convenient, only these are not, and for what reason? Because the answers are also available at page 190. The answers are all on record. Why is it that only 18 to 22 are found wanting? And there is absolutely nothing on the record which can tell.
Record that this was done for all the candidates, not only for.
No, it was not done for all. They say that it was done for others. Now, my lords, please see. They say they gave in sealed covers. We do not know anything as to whether, my lord, it may be, my lord, I am not challenging the idea of moderation. It may be required in given cases. But my lord, in my case, the manner in which it has been done, successive 4 questions just scored out like that, overwritten and done in this. My lord, whether a clerk has done this or a head examiner, at least, my lord, it appears to me that this is not someone of the caliber of a head examiner. This is not the way a head examiner would conduct himself.
Methodology may not be the perfect way.
My lord, it's not just perfect, it is improper way, if I may, with great respect, my lord. And my lord, High Court says earlier we are not satisfied with this because they don't disclose norms. They don't disclose
internal phase 5, para 5, internal phase 5.
Yes.
Of the judgment.
Yes.
Para 5.
Yes, my lord.
This reproduce an interlocutory order of 12 September 24. Just please read it and tell us what were those documents which were produced before the High Court.
My lord, we don't know. That's a whole problem. It was not, whatever was given was handed over in seal, they say. So I have no means of knowing, my lords, whether, I'm not saying that moderation cannot be done. Of course it can be done. But the point is that it should be done in a proper manner and I should also have access to see what the norms are. You don't disclose how.
exams.
In the substitute, which you appear.
Did you hear from examination?
Then what is the point?
Student qualified.
190.
When exactly?
The corrections are
22. And you didn't make.
In the subsequent. My lord, but this is so clear, my lord. This should not have happened, my lord, to take up. But I can understand if there's something because the answers are also on record.
The moderation is permissible.
Yes, yes, no difficulty.
A uniform criteria as per the High Court, the record shows that a uniform criteria of moderation has been followed. Now, this head examiner or the subsequent person whom the moderation work was assigned, the only blunder he has committed is that he didn't sign it.
My lord, may I respond? Number one, he has not signed. Number two, a head examiner should not overwrite like that. Number three, my lords, this is head examiner. The idea is that you have uniformity and they can make changes if they feel they need to even it out. Now here, there were multiple head examiners. It was not, they had different groups. Examiners headed by one head examiner, and then another group would have another head examiner. That's what they've said in the affidavit. So if that is the case where separate head examiners are not going to create the same uniformity, the whole purpose is lost. So, my lord, there is absolutely no system, and it opens the door for, my lord, for a lot of manipulation. And it's really remarkable. Why is it 18 to 22?
Question is that this examination was conducted by High Court or by Public Service Commission?
My lord, High Court.
This much we will give margin that there is no occasion for manipulation. Why?
Well, we don't know whether it is somebody from, my lord, we don't know who it is because the way the handwriting works, it's almost like a, my lord, I don't want to say anything, but no head examiner, a genuine head examiner would not have written it like this. That is, we are finding that very difficult to fathom. Could not have been, because you would properly say like this, etc., marks written. And the circumstances in and altogether, the questions, total 4 papers, nothing is touched in the other papers. So it appears to be, my lords, some manipulation. My lords, please consider some other option for her in terms of whether supernumerary or some option for her, because this is really, I mean, it's a young career, my lord. And she made it to the cutoff. And her answers are all there to see, my lord. There is nothing which one can tell from the answer that it does not meet.
The difficulty is, it's a 3-tier examination process. You have crossed the first tier.
Yes.
In the second tier, you don't make it to the cutoff. Then there's a third tier of an interview. So even if we permit or we feel that there was some irregularity here, you don't get a right.
No, my lord, I made it to the interview with these. Yeah. Yes, that's the whole point. Lord, please give me some opportunity. And see my answers, they are all there to see. There's nothing to hide from me, my lord.
Problem will be that if we interfere in moderation with respect to one candidate.
Well, no one else has come. But I think there is a lot to be said about the manner in which this system is being followed. You cannot, my lord, moderation cannot be weaponized like this against a candidate. That is what has been done. Well, and sealed documents, I have no way of seeing what happened.
Even the earlier orders that had clearly says that they
Yeah.
I have to examine sympathetically, that's all we can do.
Please consider that. I think that would, a direction from your lordships would certainly.
Presentations always.
Whereas on the petition was a candidate in Rajasthan, judicial services for recruitment to the Rajasthan civil judge. As the petitioner was a candidate in the Rajasthan civil judge recruitment examination 2018. There were 197 posts of civil judge in bracket junior division for which the examination was conducted. After qualifying the preliminary examination, he appeared in the main examination and having obtained the requisite marks, Comma was called for interview. In the final selection, the petitioner could not make, as she was awarded 147.50 marks as against the minimum requirement of 153.5 marks in the general category. The petitioner, the result was declared after the interviews were conducted on 9th November. After the interviews were conducted on 9th November 2019. The petitioner immediately replied so when after conducting the final result was published on, once the interviews were conducted, final result was published on 9th November 2019. 19th November 2019.
The interview was between.
After the interview.
For the interview, the final result was declared on 19th November 2019. The petitioner immediately moved an application under the Right to Information Act and obtained copies of her main examination, question paper cum answer booklets. There she found that her 7 marks were reduced in law paper -Roman 2 as a result of moderation. It appears from the photostat copy of the answer sheet, which has been placed on record, that there are cuttings and some overwriting. The petitioner accordingly approached the High Court for a petition filed in the year 2020. That petition has been finally dismissed on 12th February 2026. Giving rise to next, and senior counsel for the petitioner vehemently contends that in light of the cutting and overwriting, which can be seen with their eyes, it is a fit case for this court to interfere and protect the future perspective of a young aspiring candidate. Next paragraph. It however seems to us that entertaining of these postings at this stage will open Pandora's box. There might be several other candidates who too lost in the final round due to a very little difference of marks. And such difference, a little difference in the total marks, maybe on account of reduction of their marks in the moderation process. Next, at the same time, keeping in view the fact that the petitioner had qualified the preliminary examination, main examination, as well as the interview, we grant the petitioner liberty to submit a representation to
exercise of our powers.
to invoke our powers under Article 142 of the Constitution and allow the petitioner to submit a representation to Honorable Chief Justice of the High Court, who may Chief Justice of the High Court, who may submit a representation to the High Court. We have no reason to doubt that such representation shall be sympathetically considered. Regardless of the fact that the petitioner's challenge on the judicial side has failed. It goes without saying that in case the competent authority accepts the petitioner's representation, her appointment shall not affect the seniority of any judicial officer who has already been appointed through the same selection process or the subsequent selection processes.
Yes, great.
We request the High Court to take an appropriate decision within a period of 2 months.
So very grateful.
I think we can only indicate this much.
Most grateful.
Grateful, my lords.
But perhaps some norms now need to be obliged to.
May please, Lords. Because item 18 pertains to the builder buyer and the bank matters, my lord. At the outset, I must say, my lord, this was not a subvention scheme, my lord. But Great. Lord, can I request for a stay of the recovery proceedings, please? Because the recovery proceedings are going on, my lord.
There is an interim order, sir, has been.
I'm so grateful, my lords.
Item 19.
The connected matter, my lord, is already issued notice.
They also be
किले के ऊपर भी नोटिस देना है.
Notice recommendation delay also. Returnable. What is the date in the other matter?
4th August 4th.
4 August 4, 2026. Tagwi vessel please one.
Stay of the order.
We have already stayed in the other proceeding. How much time we will repeat this stay? Oh, that day one point we are probably like to interfere in this order. Item 20.
Lordship, by way of this present petition, I have challenged the constitutional validity of 84th and 87th constitutional amendment for being violative of the basic structure of the constitution, insofar as these constitutional amendment mandates that the representation in Lok Sabha will be based on 1971 population and representation in Vidhan Sabha will be based on 2001 population. Your Lordship, India is a representative democracy. And the original constitution say the representation in Lok Sabha or Vidhan Sabha will be based on the latest public census, population census. But the parliament, by way of this impugned constitutional amendment, has excluded 70% Indian citizens 70% of Indian citizens are born after 1971, not before 1971. And Parliament has excluded all of us. We are not even considered for the representation purposes. Lordship, consider the situation of Gurugram in 1971. It was a village. Population was 50-60,000. Now it's around 25 lakhs. Same with Mohali. Mohali was not in existence at that time. Noida not in existent in 1971. And now see the population of Mohali, Noida, Gurgaon or other urban cities, Your Lordship. The place of residence.
How do you say that they will not be considered?
Lordship, because the Article 81 says.
Please read how do you argue? You see, we appreciate your argument that if 70% of the population is excluded, then what kind of delimitation exercise? We understand, we appreciate that part. But how do you say what is the basis?
Lordship, because Article 81 itself says that a portion 1971 population will be considered for the representation in Lok Sabha. After 1971, people who were born after 1971 are not even considered.
And right to vote are two different things. Bhai, kya kar rahe ho aap?
Lordship, I'm saying apportionment and delimitation.
So right to vote has nothing to do with delimitation.
Lordship,
whether you are in this एक कौन सा गांव है?
I'm from Jhajjar district, Haryana.
Jhajjar district. Jhajjar, how many constituency we have in Jhajjar hai? Badurgarh now, Badurgarh is in Jhajjar or?
Vidhan Sabha constituency.
There are 3-4 assembly constituencies.
Yes.
Now, whether your village is in Badurgarh, Jhajjar constituency or your village goes to after delimitation to Badurgarh constituency, it cannot deprive you a right to vote.
No, sir.
You have a right. That is a different.
I am not on the right to vote. Your Lordship, I have right to vote. But
therefore, please don't.
Lordship, ultimately, I am voting for my representatives. But the Article 81 says the representation in Lok Sabha will be based on 71 population. I am voting.
Nobody can deny you. Nobody can deny you your right to contest the election if you fulfill the eligibility conditions under the representative that act or whatever under the constitution those are prescribed. The moment you fulfill those conditions, any delimitation exercise, any SIR, any census or any such exercise cannot deprive you from contesting the election. That is your right to contest.
Lordship, the political justice as enshrined in preamble, it says
you can contest from any constituency, even if you may not be a domicile of
domicile.
I can vote, Your Lordship, but my
you can contest election, not only vote. You can contest the election also.
Your Lordship, I can vote, I can contest. But Lordship, the political justice as enshrined in preamble, Your Lordship, it says one person, one vote, one value. The value of my vote has been reduced. It has been diluted. The population is increased, Your Lordship.
The value of the vote may be diluted against the entire population, but when you see federal constitutionalism, the value of the vote is not diluted vis-a-vis the states. The states, if you had seen, if there was a asymmetrical balance, that state A, the population of 71 is considered, and for state B, 2011 census is taken, then the value of vote changes. But since the value of the vote has been on par with all the states, there is not an asymmetrical approach either to democracy or to federalism. Only where there will be an asymmetrical approach to the representative composition of the Rajya Sabha, then the question arises.
Lordship, I appended on page number 64 a comparative population and representation chart.
Your interest and your knowledge in constitutional law, you should continue with that. Not many young lawyers are having nowadays interest in constitutional law. Of course, in practicing those in high courts and Supreme Court, they are well versed. But particularly in district courts, nobody bothers about these constitutional principles. So we appreciate that, but then your question probably which you are raising is not really arise for determination.
Lordship, for a moment, kindly come to page 64. I have appended a comparative population and representation chart. Page 64, your lord.
You can study, you see, some of the issues which might require a kind of a legislative intervention or a policy intervention. You may represent to the competent authorities, they may consider it.
Lordship, for this only it can be undone by a constitutional amendment. 2/3 majority is required for that.
Therefore, you can always persuade and impress upon those who can amend the constitution.
My sole argument is the parliament has changed the original constitution.
No, that you.
For a moment, kindly come to page 64. For a moment, kindly come to page 64.
Page?
64, your lordship.
Yes.
This is the table of comparative population and representation chart, your lordship. Uttar Pradesh, your lordship, in 1971, per MP, the population was 10,39,000. In 2011, as per the latest published data of your lordship, the population per MP is around 25 lakhs. Then your lordship, in Tamil Nadu, it was around 10 lakhs. But now in MP,
This increase in population has nothing to do with constitutional amendment.
Lordship,
increase in population that's a matter of record.
Lordship, may I read Article 81 for a moment? Lordship, Article 81 talks about composition of House of the People. Subject to the provision of Article 31, the House of the People shall consist of A, not more than 530 members chosen by direct election from the state. Then B says not more than 20 members from the UTs. Then Lordship, the clause 2 says, for the purpose of sub clause A of clause 1, A says, your Lordship, there shall be allotted to each state a number of seats in the House of the People in such manner that the ratio between the number and the population of the state is so far as practicable the same for all states. It should be same for all states. What I'm saying, your lordship, it is not same for all states. After increasing the population, the value of my vote has been diluted, your lordship. It is a clear-cut violation of this provision, your lordship. Then it says, your lordship, each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituencies and the number of seats allotted to it is so far as practicable the same throughout the state. It is talking about the constituencies in the same state, your lordship. Then clause 3 says, your lordship, in this article, the expression population means the population as ascertained at the last preceding census of which the relevant figures have been published. This is the original constitution, your lordship. Clause 2 says it should be as far as practicable, same for all states. As of now, your lordship, it is not same because they are relying on 1971 data. In clause 3, lordship, they says on which population data the states shall rely. It says it means the population as ascertained at the last preceding census of which the relevant figure have been published. By way of an amendment, your lordship, they have entirely override the main clause that you will rely on the last published data. By way of an proviso, they have said you will rely on 1971 data for Lok Sabha and 2001 data for the Vidhan Sabha, your lordship. They have completely override the main provision, your lordship. They have completely changed the original text of the Article 81. This is my sole argument, your lordship.
Really, problem is how to entertain it. Make some representation, make the authorities aware that the way you want a new amendment in the constitution. Ultimately, it is the people's idea. Innovative, sometimes it may look, but you never know that which idea may click at any particular stage, and the representative of the people, they might think of amending the constitution the way you want. That all depends on. After all, they are all our representatives only.
Only your lordship can question, your lordship. The parliament will have to pass another constitutional amendment to undo it.
it is something in their domain. We appreciate Mr. Nishant as a young lawyer that you are taking so much interest and making very good analysis also of the constitution. Sometimes we may not agree with you, but we appreciate the way you at least have understood the constitutional principles and philosophy behind it. एक रिप्रेजेंटेशन वहां भी दे करके देख लीजिए.
वहां पे जैसे कुछ होता तो सर, I wouldn't have filed this petition because they have to pass another constitutional amendments.
No, we will not use the word dismiss.
They try to
say, we will say
131st constitutional amendment. They try to introduce in parliament, but that failed, your lordship, because they don't have 2/3 majority.
No, that's right. But we will not say that we are dismissing the petition. We will say, as a lawyer, since you are a lawyer, we will say that you want to withdraw it as you would like to make this petition as a comprehensive representation to the different stakeholders. That will be your. All right, thank you.
My lord, it is a public interest litigation for the sanitary napkins, my lord, which are currently being distributed through Jan Aushadhi Kendras. My lord, Government of India has done a commendable job by reducing the cost per pad, which is in retail market available at ₹10, my lords, is available at ₹1 now, after the exemption of the GST. And my lord, currently the happening.
Okay, maybe enough, but
issue notice. I think that can help our young doctors and children.
Highly obliged, my lord.
Stars. There is
Mr.
a request.
And Mr. Tushar, since both sides are present, Mr. Salman is also there. We will issue notice and list these matters for final hearing on some date where both sides are, you can have sufficient time.
Status.
We can hear it for one day, maybe it will require, I think, hopefully in one day it can be argued.
Yeah, but there is a status quo, my lords, which has continued since 47 till the impugned judgment. Now, the archaeological survey order is of 2003, which was challenged after 19 years in a writ petition. The High Court, my lords, when it passed a final order, in all fairness, should have given us at least breathing time to come to the Supreme Court. Where was the question of, my lords, not even granting a stay for a week, when that is the status quo which had continued since, my lords, 47? Now, therefore, today, I'm only saying that the earlier status quo, the ASI order of 2003, very clearly said, one day in a week, my lords, you can offer prayers, you can offer namaz on Friday, and, my lords, on a particular day, apart from the Purnima festival, you can always offer, you can always have the prayers on Wednesday. You can have puja, Tuesday. Now, therefore, my lords, if that status quo has continued by a statutory order from 2003 till the date of the judgment, today now we have been completely ousted. And it's very, with the greatest respect, my lords, I submit it's very unfair. And there are fundamental issues which arise. The first issue, the primary issue which will arise is whether a writ lies and whether you can rely on ASI reports. Those persons who have made the reports are not even subjected to cross-examination. You determine, my lords, highly disputed questions of fact by virtue of a writ petition.
Well, may I just say, I am unexceptionable that your lordship will hear it. I am told your lordship said so. That is unacceptable, and I would welcome that and invite that. Your Lordship should hear it. Without opening a single page, give me just 3 or 4 minutes on oralizing why there should be some interim arrangement. Whereas the reason is this. Whereas kindly give me a minute. Whereas the larger issue is, I'm only oralizing the issue-wise. First and larger issue, which your Lordship will decide on the hearing, I understand. Well, India is one of the country of layers of history. Layers will always be there. If you go behind layers, there is no end. It is Gandhiji's an eye for an eye, everybody will be blind. That is the rationale behind the 91 Act enactment. The SOR says that we make a one-time exception for Ayodhya. We will not. I accept that some of these may have, I'm not talking of this, some of these may have had a temple. There may be a temple, Jain temple apparently supposed to be under the Qutub Minar. As a Jain, I was taken there and shown something. But that is no reason to go back on layers of history till time starts. That is why 91 Act in the SOR was enacted, number one. Now, there is the larger public interest of 91 Act being preserved, otherwise there will be chaos in this country. There is no end to it. This is not a general point. Your Lordship has an actual order by a High Court in Allahabad saying that somebody should at least start a survey of the Taj Mahal. And I'm not about particular. This can go on endlessly. So the quietus is the idea in public interest by an enactment which is either not set aside or the 91 Act is pending challenge and decision by Lordships in a validity petition. Second, just 2 minutes more. I'm sorry. Second, now, the impugned order, with greatest respect and humility, does a sleight of hand in interpreting it knows the 91 Act is a bar. The 91 Act section 3 is a complete bar. The impugned order invokes 4(3), which is a exception to 4(1) and 4(2), not to 3. And says that the ancient monuments system can operate. Number 3 is very important. There is a continuous 700 years of daily, I'm not asking for that, but continuous 700 years of daily namaz at page E, we have said. The 1907, 8 and 1927-28 survey says it is a namaz place, a masjid. Post 1947, the Khasra Khatoni at page 286, 287 say it. The MP Waqf Act notification at page U says it. The most important, the Dhar Area Darbar Gazette. Your Lordship knows it was Rayat, it was the Darbar. They issue a gazette in 1935 at page 285, that says it. And therefore, namaz is allowed along with Basant Panchami. Actually, it's an excellent example of communal harmony, if I may say so. From 12th of May 97 order, they allowed namaz at fixed times along with Basant Panchami every year. It continued from 12th May 1977. Then the most important order which I am asking to be replicated today in the interim till Lordship hears it. From 7th of April 03, namaz is allowed from 1 to 3 p.m. Basant Panchami is celebrated the whole day, and Hindus on Tuesdays can use it for sunrise to sunset. From when is this going on, with deepest humility? From 2003, uninterrupted. In between, when a writ is filed by the Muslim community, that writ is held to be non-maintainable, saying go to a suit. That writ is carried in writ appeal. It is pending, saying let the writ decide. While it is pending, the Hindu community, the current one, goes in a writ. The impugned order is passed, ignoring a coordinate bench which says you can't have a writ, go to a suit. Yeah. And this Mutawali, which is for whom I am appearing, who is the person who has gone there, is not allowed to be impleaded. The court holds you may have a right of audience. But with the deepest respect, this is a larger issue. Well, your Lordship has one word in the preamble, which is the most forgotten word, according to me, possibly the most important: fraternity.
And
you have then secularism, and fraternity and secularism cross-fertilize each other. I'm asking myself one question, if there's a 91 Act which says directly one-time exception Ayodhya, and there is a 7403 continuing uninterrupted interim order by your Lordships, observed till today, then between now and then, something which has continued for 23 years, your Lordship decides the matter, that should continue. Now turn to that order, for a minute.
Only one thing before my learned friend starts on the merits. There is something,
The order impugned is 15th of May 2026. It's 2 months down the line. Lord, several things have happened. Lord, I appear for the administration for the state of Madhya Pradesh. Several things have happened, my lord. And my lord, I have prepared a short affidavit, my lord, whenever it's necessary, my lord, or required, my lord, I'll place it on record. Lord, right now, your lordship's, my lord, suggestion that it may be heard at the earliest. My lord, we can assist your lordships, my lord, on that.
In fact,
But
I
we have,
want
my
to
lord,
join in
for
with the
administration, we have ensured, my lord, that both communities, my lord, keep calm. This
See the
any
order
kind
at
of, my lord, status
Mr.
quo
Mehta
ante
will agree.
without hearing.
Really, my lord, the
I am
ante
sure
will just
Mr.
create a
Mehta will
problem.
agree if he
The
sees the
ante
order
is the problem.
305, page 305, just see the order.
They are really in
I
effect
don't
and in
understand.
substance asking for a stay. That's what they are
One
asking
second,
for.
one second.
And they're saying status quo ante.
The PIL petitioner may not agree, but Mr. Mehta should agree. 306, page 306. PIL
No, it's
petitioner
not
may
a
not
question
agree.
of agreement, but once you come after 2 months and 6 status quo ante, the administrative problems come.
No, but the High Court then should have in all fairness stayed its own order.
No, my lord,
Malad, kindly see,
that
there's
has
a
not
fairness.
done. You should have
I didn't come after,
I didn't come after 1.5 months. There
came
was a
after
vacation which
26
entered.
years. You came after
Shouldn't
23
the High
years.
Court, Malad?
You came after 23 years.
I'll arrest after
First
Dr.
of all,
Singh.
our-
Malos, there's one thing that I
Can you show 306?
May I also make one small request?
Yes.
These are very sensitive matters. What is happening inside court number 1 can unnecessarily create wrong impressions, wrong messages.
Yes,
absolutely.
We should be extremely careful in using any expressions or anything.
Lordship.
We not first time this interim arrangement issue is coming before us first time. Earlier also we have dealt with the High Court and the helplessness of the state in maintaining on certain issues, on land order issues. Those have also been taken notice in the influence judgment also we have seen it. That's why we just thought that whatever system is there, if we can list in after 10 days, 15 days before a bench.
Absolutely.
My problem is that first bench, I have already said that 7th bench matters we are starting and 3rd bench matters are going on. If both sides.
Any earliest date, my lord, we are
bow down to that.
That's all right. That's very nice to say. Manoj. I can't say more than this. Of course, also your lordship, 9 Judge 25, 26 articles will also have a very clear impact on the whole thing. Just note the order of 306 for 1 minute. Then your lordship will see whether this is the most outstanding example of Samanvaya and harmony. Just see this. It's worked itself out for 23 years. Of all people, why should Mr. Mehta's client, the government, oppose it? 7th of April 2003. In item 57. Yes, in item 57. Page 306. Page 306.
This is 2003. This is set aside. Yeah. In fact, the problem would
after
have been
23
solved
years,
if
Mr.
they would
Mehta,
have
it is set
immediately
aside
moved the
after
matter.
23 years while the appeal is pending here.
They would
I
have
gone
moved the
Chatterjee.
matter earlier
Allow
to
me,
file
allow me,
it in
please.
May and moving it, my lord, in
Please allow me,
July
please allow me to complete my sentence. I, Gon Chatterjee, Director General ASI, in exercise of powers conferred on Rule 4 of the ancient so-and-so rules, in partial modification, all my 3 lords have it, please, do hereby direct that the central...
This order we have read in earlier round of.
Exactly.
This is covered, it has worked itself out. It is a good via media. It's a good via media to preserve stability. And prior to this, it was only the Muslim Samaj, namaz, followed by Basant Panchami. This expands it and says every Tuesday from sunrise to sunset, Hindus shall have a right. So it's an expansion.
It's a matter of 10 days, my lord. Your lordships can always do that, my lord.
My lords,
My lords, I just want to say one
after
thing
my
for
learning.
my lord's consideration. There is a consent, there is a kind of a understanding. It is called Sehmati. It is dated 23rd of April 1995, apropos to which both parties have agreed to use it as an religious place, both the Hindus as well as the Muslims. They are doing that continuously from 1995 under that Sehmati document until date. Now, my lord, so far as the maintainability of a writ itself is concerned, after the order of the learned single judge saying that the writ is not maintainable originally and saying that it is to be relegated to a civil suit, it was carried in an LPA brought before my lords, before this court, and that order attained finality. So today, if there is an order which has clearly said, in this given factual facts, a writ is not maintainable and my lords have put the approval on that particular order, it has attained finality, I would ask myself a question that how would a writ now, and particularly when a suit is pending, it has been filed, a writ, in a writ this present on one thing, and I appeal to my lords in that. I think Sofia Haya in Istanbul is a classic example. A Christian church taken into a mosque, but as of today, nobody offers any worship there, but they maintain the place as it is. My lords, many other countries.
Which place are
Istanbul.
Hagia Sophia.
Hagia Sophia, my friend is talking.
Classic example
Maybe
of
not
maintaining
comment. I have been to that place. I have myself seen it, but I will not. I don't agree what you say, but I will not comment on that.
I leave it. That could be a view. I lost a different view. I would leave that. But I would respectfully submit that today, if we have an understanding document between the communities, they have acted upon it from 1995, and we are 30 years, 31 years from that. And my lords, there is a judgment that has attained finality on the maintainability of a writ petition, and there is a suit which is pending.
That is an issue. We are inclined to determine that issue.
For the
Of maintainability will be an issue to be examined by the interim.
I come to the interim. I would say, my lords, most respectfully, and I would request my lords to consider that if for these years, and it's back to the 12th century, 1200, if the mosque dates back and has an antiquity of that date, and there are worship that is being offered for the last over 800 years, my lords, why should that be discontinued now? My lords will decide, but if the parties have also been doing it in harmony, that's the best thing that can be taken forward. I would say after 800 years, to stop worshipping by a community, my lords, it will be a little bit too harsh. And frankly, if the parties have been jointly doing it under a settlement of 95, why should that not continue to hold the field till such time as my lords decide on the matter? Because we may have different views on different things. I don't have an issue there at all. But the fact does remain that what would be the arrangements that would hold
When
the
your lordship issues notice, your lordship does continue the interim order if there is an interim order or status continuing in the High Court order. This is changed only by the impugned order. This is changed only by the impugned order.
Should we please be over-conscious rather of let us not pass any order which might lead to creating tension and law and order crisis at this court. We should all be very cooperative on that part. We are ready to hear the matter on day-to-day basis. I will request even if it comes before our bench, there is no difficulty. Even if it goes to other bench, we'll list it, we will request the bench to take it on day-to-day basis, resolve the issue finally. These arrangements were there, the archaeological surveys order has also been creating problems, and Mr. Salman Khurshid will appreciate because in some of the matters earlier came before our bench.
Yes, he appeared.
Despite these arrangements made by Archaeological Survey of India or subsequent modification by that, there have been issues at the site, and because of that, some intervention was made at that time. So,
but if it is continued,
it's a matter where both sides we will request should have patience, and it's a matter of it can be 2 weeks, 3 weeks. You should also be ready. They can also be ready.
Yes. I bow down, my lords, to what is falling from my lord the Chief Justice. Given the nature of the matter, the kind of order passed by the High Court, I respectfully submit, let it be taken up for hearing, my lords. That's only appropriate in the facts and circumstances, my lords. I bow down. We will cooperate, my lords. We will argue straight away. Because that's the most imminent
administration
approach.
Has been very, very careful in choosing my words also. Lord, since they have chosen to come after 2 months, some events have taken place, and now with the intervention of the administration, situation is calm and peaceful. Lord, let that not be, my lord, muddled, and it's a matter of 10 days, my lord. They could have come immediately on 15th of May, 16th of May, 17th of May. But now we are on almost, my lord, 2 months. So therefore, my lord, I believe, my lord, with profound respect, my dear lordship, rightly considers that it needs immediate examination.
And today they would really be arguing for status quo ante, my lord. That's really the problem. And the 2003 arrangement, what they are repeatedly talking about, you cannot perpetuate a problem. And that has now been seen to be incorrect by the High Court.
My petition was filed on 20th of May. Serial.
So all the more reason they should have pushed it earlier.
They didn't move it.
3 out of 4 were filed in May.
Well, may I,
3 out of 4 were filed in May, and if there is been no serious disturbance, the government can maintain Mal's peace now also under your lordship's order.
well, may I,
Nobody made a mention before us.
Absolutely, my lords.
In fact,
After 10 days, will not and continue.
no, it's all
well,
right.
may I just state a few facts, subject to your lordship's pleasure. For the purposes of, your lordships have indicated that your lordships are inclined to issue notice. So at least that hurdle, my lords, I clear. Now, my lords, just a few facts, my lords, that I wish to state for the purposes of grant of an interim order. Where does the balance of convenience lie in the interim? And what is the interim order that your lordship got to pass today? Just a few facts. My lords, the High Court also says in the impugned order at page at 239 that from 1400 onwards, this is being used as a mosque. Point number 1. Point number 2, my lords. Your lordship just has my paper book. In 1935, there is, my lords, a statutory order. They say that it could not have been passed, etc. But whatever it is, factually it recognizes that this was always a mosque, was being used as a mosque, and will in future be continued to be used as a mosque. Just see that at page 286. Just 286. I am item 53. Please see this at 286 of item 53.
Item 56. His petition.
Your lordship sees the date, Manoj, just as Bagchi has that. I am obliged to. This is the proclamation of 24th August 1935. A royal proclamation. Justice Mohana has that. My Lord the Chief Justice. I am obliged.
No,
This royal proclamation is being made in order to clear a misunderstanding
just for identity.
in the minds of Muslims
53.
arising.
This is item 53.
Item 50.
Item 53. If you can give the name of your bill, just for
Yes.
identifying.
The name is Haji Munir Ahmed
Haji Munir.
and another.
Where is that? Just taking it. But I think it's not served. It's not served, Manoj, to the caveat.
There was no caveat in this matter. But anyway, I'll give him a copy.
No, that's okay. I mean, it's not a
This
technical.
order
No, no,
is
correct.
the matter which
It's not
is
an
served.
objection.
The same order is filed in all the
But
matters.
in any case.
Now, Manoj, kindly see, just
Allow me
let
to
me finish,
finish.
if you don't mind. Yes. So this is the order of 24th August 1935. Royal proclamation is made in order to clear any misunderstandings in the mind of Muslims arising from the notice issued by PWD outside the compound of Bhojshala and Maqbara of Kamal Mola, in which the word Bhojshala has been mentioned, and will not be converted into any other kind of monument. There is no ban on namaz being offered at this place, as presently being done in future. As also there will be no bar, and that there is a masjid will remain a masjid in future as well. Dated 24th month of August 1935. So 35, my lords, is this declaration, which is a royal proclamation. Thereafter, my lords, 15/10/1951, there is a letter and a clarification by the archaeological department, which says very clearly that this structure is a mosque. Page 287, the next page. Your lordship has that letter from the Ministry of Archaeology, the very next page, 287. Now, my lords, in this.
There is a typographical error.
Yes, my lord.
That date is 24th August 1935, not 1955, as para 1 says. And this is the same notification which is P4 at page 286.
This is 1924.
Page 287.
We have 287, my lords.
Para 1, if you read the Bhojshala on the Kamal Maulana mosque had it.
Yes, my lords, that's a typing
By
mistake.
the former Dhar state by a mosque so and so. To this effect in the Dhar state Gazette dated 24th August 1955.
It should be 35. I take your lordship's point.
The same notification.
It is 30.
Just read.
That's correct. So So this also says, as on 51, that it's a mosque. Now, my lords, thereafter, my lords, you have 1/5/1952, which is also a document, my lords, by the Education Department, which also says that this is a full-fledged mosque. After that, my lords, you have 21/1/1955. The collector Dhar denies permission, which is sought, my lords, by the Hindu Sabha for the purposes of puja. That your lordship will get at 304. After that, my lords, I'm just giving, and then I'm just coming to my point on the interim relief. Thereafter, my lords, 18/1/1985 is my lords at page 3.
Operate just the directions which have been issued by the division bench of the High Court.
Yes. Your lordship sees the last part.
Yeah, just a minute, Mr. Uzefa.
Yeah.
If you don't.
I'm on my legs, so that.
It's 241.
Everyone is on here.
Everybody on the neck.
Yes.
211.
Unfortunately, the chairs from the front row have been moved, so we can't take a seat.
So we are truly standing outside.
That's for accommodation.
Lordship, please.
You see, there are three directions. One is that
241, Mr. Solicitor, 241 of the one that is served upon you.
Yes.
Qazi Moinuddin.
Yes, madam.
Moinuddin, 241.
It starts with Roman 1. Yes.
That these were judgment, this is the
Yes.
directions given.
Disputed area.
you see, a 241, three in directions. One is direction number 2.
Religious
The religious character of the disputed area of Bhosala complex and Kamal Mola Mosque is held to be Bhosala with a temple of goddess Bagdevi Saraswati.
But this has been, there is an installation of something. Therefore, 2 months have some significance. I'm not taking sides, but we are concerned with the law and order. Yes.
Yes, we are just pointing out. Then this archaeological survey order of 7th April 2003, to that extent restricting rights of Hindus to worship Bhosala, that has been quashed.
Yes.
Now the complete structure has been handed over to the Government of India and ASI.
Yes.
Will take the decision for the purpose of administration management of graves of Bhosala so and so.
It's all right. Next 5 is ASI will fully supervisory control over the preservation, conservation and regulation of religious access.
Because it's a heritage, it's a
No-
archaeological site.
No structural changes are to be made by Government of India or by the
By anyone,
by any authority except under the supervision, control and the management of ASI.
Correct.
Right? Now, then comes this number 6 and rather 7.
6 is not.
Alternate side.
Yes.
But how did you put the goddess? Because the goddess from
No,
UK museum must come and be put there.
No.
That is the-
No, my lord. Let me make it clear. My lord, I have consulted
Because
your lordships are right.
who with seats, the Bojala temple must, as per the judgment, have the idol of goddess at London Museum to be brought by the government of India.
No. Let me factually correct, my lord. I have taken instructions from the district magistrate. My lord, earlier the photograph is available. That photograph is placed and daily puja, archana, etc. is going on, my lord. That's all. That's not the idol, my lord, from the London.
But if this judgment is to stand, the only area where the government gets involved, apart from ASI, is clause 6 and clause 7.
No, that is
One-
central government. State will be involved for the law and order.
Government to bring back the idols
I
from
understand.
London. Like,
Well,
that is for you to appeal then.
Central government.
That is for you to appeal.
I would even like my lord Kohinoor to come back. My lord.
Well, somebody can file a content petition.
4 and 5 also is important.
I understand. I understand what is calling.
We don't want as a constitutional court to make a comment about all the artifacts in foreign museums of colonized countries. But at least one Indian court has directed a mandamus.
I must share with your lordships. One of the honorable prime ministers of London, of Britain, came to India and visited Amritsar. And the journalist, my lord, kept asking questions. One mischievous journalist said that, are you going to front? And very witty. He said, if we start giving everything back, then our museum will be empty.
In fact, my lords, we have the dubious distinction, my lords, of going and standing in a queue, paying for and witnessing the Kohinoor, my lord.
And seeing the best artifacts of
Best artifacts, my lords, are all being displayed. We pay for it and go and see it.
Yeah, Maharaj, I just want to, if I may just complete.
And the learned advocate general is also here. The state and the union both are.
I appear for state as well, with learned.
Number 7, it will take some time to comply with. You will have to identify a site and maybe construct.
Yes, ma'am. Yes.
Is there any open space near this subject site which can be offered for the purpose of?
Yes, certainly, my lord. We will.
I just want to say.
We will definitely, my
I
lord.
just
We'll
want to
work it
point out 2 things and then I leave it.
Mr.
Yes, ma'am, I take
Salman
the
was
point.
there, not the last officer.
I had.
Mr. Salman was
here last time
when arose in the working out of the 2003 ASI direction.
Yes.
The right day fell on the Basant Panchami.
Basant
Panchami.
And we worked it out, subject to the assistance and directions of the state administration,
Yes.
that since the Basant Panchami puja, which the solicitor says, there is an idol, and the puja was going on, and Mr. Jain's concern was there will be devotees, and if there is a namaz offered, the persons offering namaz will be disturbed.
Yes.
Because there will be, they also will like to have it in a proper and pious way. At the same time, the devotees, so there was an arrangement made with the assistance of the state administration that an adjacent area was used for the Friday namaz.
That's right.
At the same time, puja was.
Yes, yes, my lord.
I take the point.
We can definitely.
Maharaj, I take the point. I just want. Maharaj, I take.
The government implements subject to our hearing of the appeal. Roman 7.
Actually,
Maharaj, may I just, I just point out 2 things, Maharaj. I had reached up to Maharaj 1985. just let me just state 3 facts and then I leave it to your lordship as to what interim arrangement should be made. Now in 85, it's a matter of record that this,
we are referring to an.
if I may just state
Just
two
only
facts.
one line, then you
No,
can.
like-
For 10 days, Malad, and
Yes.
we are, Malad, government
Yes.
is open. There's no difficulty about it.
Interim arrangement.
Yes.
Which we were able to persuade both sides.
Yes.
And that was made during the time when the issue of nature of the structure itself was sub judice
Yes.
and not adjudicated.
Yes.
Today, rightly or wrongly, there is an adjudication.
In a writ.
In a writ.
In a writ.
That's right.
Yes.
There is an adjudication.
Yes.
They moved writ petitions.
Yes.
I mean, which.
We are only trying to make that ad hoc arrangement for the purpose so that no disturbance is caused
Yes.
and there is a space available for offering namaz. Till the matter is decided by this court, it will be purely an ad
Well,
hoc.
I,
And without
yeah,
prejudice.
but let's I take your lordship's point. May I just respond to it very briefly? So there can be 2 ways of my lords looking at it. If I may just complete the narration, 2 more facts that I want to state. After my lords pointing out the government gazette of 1935, which shows that at least since 1935, this continued to get used as a mosque. When your lordships are speaking of the spirit of accommodation, the spirit of accommodation, my lords, on behalf of this community came in immediately thereafter in 1997. Because up till then, the directions were, this is a mosque, this will always be used in the mosque. The other community, the Hindu community, does not have the right to offer prayers here. That was, my lords, the manner in which it was proceeded with. Now in 1997, my lords, the Muslim community agreed that very well, in 1997, there was an order by the collector. And the collector said that you may have Friday namaz in this particular mosque. And, my lords, let them have access to the monument, and, my lords, on the occasion of Basant Panchami, let them do, my lords, whatever prayers. This was, my lords, sorry.
Tuesdays.
Subsequently.
Tuesdays
were added.
Firstly, in 1997. So when your lordship said there must be a spirit of
Only on Vasant Panchami day.
Basant Panchami, and they can enter and probably use, but they will not cause any disturbance to prayers, even on some other days, or even on one particular day. That is thereafter, my lords, solidified into an order of the ASI of 2003, which your lordship just saw, where under, my lords, the accommodation was that you can have pujas on Tuesday, and the Muslims will have namaz on Friday. This has stood the test of time till such time that they filed a writ petition. First, my lords, I filed a writ petition. One of the parties, the Muslim parties, filed a writ petition, even challenging, my lords, the grant of rights, my lords, to the other community for, my lords, prayer on Tuesday. That was separate. That was dismissed by the single judge, saying disputed questions of fact go in a suit. So far as, my lords, they are concerned, their writ petition against the ASI order is filed only on, please don't interrupt. Now, insofar as that is concerned, my lords, what was said was that thereafter, my lords, for the first time, their writ petition comes in the year 2022. So the ASI order, my lords, has held the field from 2003 to 2022. Now your lordships were pleased to observe that there is an adjudication by the High Court. Now what happens? The impugned order, my lords, is passed by the High Court on 15/5/2026.
Now, we are pointing out something else.
Yes.
That before the High Court's adjudication also,
Yes.
there were occasions when some very stressful moments came.
Yes.
Yes. And those were resolved by us with the help of Mr. Pusid and the other side.
Yes. So I am obliged, my lords. If that resolution that your lordships effected while the matter was pending is to continue in the interregnum, that can be one way out.
That is one of
that resolution, the orders that you, because, my lords, now today the situation is we are completely elbowed out.
Just see what, sorry.
That's why we are saying that
Yes.
One fact missed out,
some adjoining area
Yes.
can be earmarked for the purpose of offering namaz.
Yes.
And that arrangement without prejudice to the rights of
Yes, only as an ad hoc arrangement, not
No,
that
but
they
my
will
lords,
give up their rights.
my lords, just one thing. The adjoining area, my lords, this today has some religious significance. For the purposes of Friday prayers, this particular, my lords, complex, it has a particular pulpit on which, my lords, there is an observance of prayer which has been going on, which is also of religious significance for us. So on one Friday, if in a week, we are permitted to offer those prayers, which we have been doing since 1935. Well, I am just pointing out one more thing.
Well,
Your lordships,
how much can be argued? It is of
your lordships
the
were
other
pleased
side
to-
also, my lord.
Your lordships will be pleased to. My lords, my learned friend never does this in other matters, my lords. Why is he doing it in this?
I'm doing it in this matter because
Yes,
my
very
friend
good.
is going on.
Let me finish. Please don't do it. Please don't do it. Let me finish. Now, therefore, my lords, after so many years, if the learned single judge even wanted to allow the petition, in my respectful submission, and this is, my lords, my ground for interim relief, should his lordship, my lords, I ask myself this question. Not, my lords, state the order for a period of 2 weeks or 1
come
week.
immediately.
One point.
Can
The government,
2 months.
after the order is passed on that particular day, the learned single judge doesn't stay his own order, even for a period of 1 week or 3 days, giving us, my lord, some kind of a platform. The very next day, there is an order passed by the state, which says that ASI, saying that this is how we are going to implement it. Muslims are out of this particular property. They can't really enter. And, my lords, therefore, now we are sought to be presented with a fait accompli. My learned friend orally said, my lords, I'll just finish in one way. My learned friend orally said, they are asking for a restoration of the status quo ante. But what are they getting? You are altering the status quo, which has gone on from 1500 up to the date of the order. Now, therefore, my lords, where does the balance of convenience lie? And today, my lords, in all fairness, is it, my lords, proper to, on a point of balance and of convenience and irreparable injury, to oust out one community, which has been performing, my lords, over there for so many years?
On that 1 minute only, my
Yes.
mistake, I did not say it is very important for your lordship's interview. It will take 1 minute. The judgment your lordship is hearing is reserved on 13th. All this, but I just realized, all this repeated intervention, 2 months, is a red herring argument. It's an irrelevant argument of Mr. Tushar Mehta. 13th judgment is reserved. 15th judgment is delivered. Now, turn to page 715 in any file. This is very important. One document. That is 16th, item 22 or other item, page 715. Judgment reserved on 15th. On 16th, the ASI issues a letter under the Ministry of Culture saying, the Hindu community shall have an unrestricted access to Bhojswala complex and the others will not. In 1 day. Even if I had somersaulted into the Supreme Court the next day, I could not have got a stay of this. So this is just a red herring argument. Has your lordship seen this alacrity? No, but both your lordship arranged for both to.
Let us not.
On the next day.
Let us not doubt too much on this kind of matters.
Check out.
A day's delay can have very serious repercussions.
Absolutely.
A day's delay, sometimes we see the psyche, we have to see the common man, how they behave, how they act, how they react.
We mentioned at 10:30 many a time. That order is passed yesterday, not stayed.
Whether it should
Please
have
take it
stayed,
up
like
today.
Mr. Ahmadi is saying, or they should have given me 2 days to come here. Just see the order. I have not yet seen an order like this.
We understand that.
It's safe on a Saturday.
Please appreciate.
1 day later.
Once a court makes a judicial declaration on a particular day, and if you fail to react and act, sometimes keeping in view the peculiarity of the situation, it might have very serious consequences at this point.
Next day on a Saturday.
Lord, I didn't want to say this.
It's an order running into
Mr.
240
Ahmadi filed his
pages.
petition on 10th July.
Access to
It was
one
not even
community,
filed and
changing the status quo
and
for
now
joint.
he's making an
Your
argument
lordship
about
had jointness. From 7403, the latest status quo for 23 years was jointness. The impugned order changed it on 15th. On 16th, how can they write a letter? Just see the document of 715. I've never seen a document like this. Bruce. On a Saturday, the next day, they say, one community is out altogether. And the other community by name shall have unrestricted access.
Will this argument really be an aid of staying of the judgment?
No,
because
of the
your
jointness.
argument is that if you see Roman II,
yes,
Roman 2, Roman 3, and Roman 5 have in fact been given effect to.
Correct.
You say that the judgment has been given effect to in post haste.
No.
When we are
I'm sorry to interrupt.
looking at the
But I'm
existence
saying
of
his
this
wisdom. Mehta
application,
and the other side.
Apropos, my lord, the Chief Justice observation. Mr. Ahmadi's SLP.
Right. I'm saying my learned friend's argument is now your lordship is restoring status quo ante. We wasted too
why
much.
they are saying status quo ante is because of that. That
Absolutely.
we are looking at a judgment which has been partially given effect to, albeit in post haste.
Absolutely. Lord, another thing, Mr. Ahmadi's SLP is filed on 10th. We are on 13th.
Mention.
My lords, also, I would request in terms of a prima
Joint
facie
test.
test.
Cannot, my lord, wait for 10
Please
days.
have in mind that this is a mosque dating back to 1300, where regularly
right.
prayers are being offered. Now if you test on that
Madam, that is the reason why we want to balance the equities, not only on the prima facie case that has been so vociferously argued before us, but also the state of affairs that, see, here certain steps have been already taken. In this situation, we see Roman 7, where the rights are sought to be preserved in the manner the judge considered, which is subject to challenge before us. We can set aside this order and restore back what was earlier there.
No, Mr. Ahmadi has no
Please, may I just
proposal subject
No
to hearing
permanent.
further.
There is no permanent.
Till a fortnight, whenever prayers are offered, without the equities being crystallized or any prejudice being caused to contentions of modification in future, that the prayers be offered in a place adjacent to this mosque or the declared temple, the manner in which it was done during the hearing of the writ petition.
No idol is
During
installed.
the hearing of the writ petition.
No idol is installed. A cardboard image is kept every morning and taken back every evening.
Correct. Now
So,
the
there is
idol
no
has
idol.
already been installed.
No.
Idol has been installed.
There is no answer, idols. I don't wish to go into it.
Sir,
When
now
Mr. Ahmadi files an SLP on 10th July, why can't he wait, my lord, for 10 days?
Background.
We are in 13th.
5 minutes.
Each one of the, just for a minute, each one of the arguments they are giving touching on merits, this has to be argued then, my lords, by both sides. For an arrangement, interim arrangement.
My lords will just allow.
Cardboard image, well, no idol.
I respectfully submit, my lords.
My lords, may
I
I?
have today's position on the photograph.
Hard enough, madam, let's not.
My lords, just.
We would have preferred to decide the main case itself. I think.
My lords, just 1 minute of your time, if you would allow me, please. My lords, it's a historically documented fact that Dhar suffered an earthquake in 12th century, which is around 1200, and everything there was destroyed. So there was no existing temple. It's a documented historical fact that the mosque was built in the 13th century. And it's all historically documented, and where there's been a continuous prayer being offered.
So do it before the bench. Assigned by previous here. Then say, meanwhile, examine matters and without prejudice to the rights of both sides, it is directed that a separate open space adjacent stroke near to the subject premises, comma may be provided to the appellant and other members of the Muslim community for offering namaz on Friday between 1 to 3 p.m.
the interest and interest to the side shall be it will ensure that exception is caused to both sides in performance of their religious practices.
That's why you allow that.
The arrangement shall be ad hoc in nature and subject to final outcome of these proceedings of the appeal.
Please, sir.
Very well.
Grateful.
Grateful, madam.
Just one more request, subject to your lordship's pleasure. Sorry. I hope I am not stepping out of my station.
No, please. No issue.
Otherwise, my lords, in all other respects, status quo should be maintained.
That creates
Because there is some
confusion. What was there,
apprehension.
what was changed?
That there is some apprehension.
Lord, Mr. Ahmadi
Pursuant to the order.
comes here on 10th July and he is
Can I
requesting on-
complete my sentence without interrupt? Yes, I am obliged. Yes. So therefore, all that I am seeking is that status quo in all other respects should be maintained as existing today.
Other respect will be a very vague word, Mr. We can say they will be changed.
That solution, solving the problem.
Yes, because
Any steps taken by
there are surrounding structures, there are other things. Existing state, the situation on the ground should not change. I can't
That will
state
only
it.
complicate the whole thing, my lord.
Yes.
That will only complicate, my lord. It will only further create confusion. Tomorrow they'll come up.
No, so therefore this is an admission they want to
It's
alter.
not been altered, my lord.
ASI protected monument.
This is
That's
going
all
to
that
add
I'm,
to the problem.
that's all that I'm requesting.
says it would be totally under the control and management of ASI.
But if the ASI intends to alter, my lords, there is some apprehension. The status quo as it exists today should be maintained. No, that is a different thing. That's not altered. I think that's okay.
Structural changes. Structural alteration is proposed by Archaeological Survey of India. It will not do so without leave of this.
Yes.
Without the leave of this.
That's very fair, my lord.
That's fine.
Yes, yes.
Absolutely.
Deeply obliged, very deeply obliged for a patient here.
Deeply obliged.
I'm sorry, my lords.
No.
I've argued for much longer than what I normally do.
No, this is a good suggestion
that partly explains my objection also, my lords.
Anyway, obliged, my lords.
Thank you very much.
Deeply obliged.
Because would your lordship give some date?
Approximate date.
We'll notify the date today itself for finally.
Lordship, please.
And we'll list on a Wednesday so that will be maximum Wednesday or Thursday, then it can.
We'll just complete the pleadings in the meanwhile, my lords. We'll complete the pleadings in the meanwhile.
That's it. And will you please file your memo appearance?
One second. I'm sorry. My apologies.
Someone is appearing for Archaeological Survey of India? Issue notice, then so and so accept notice on behalf of so and so respondents, then say heard, leave Quran, and then say.
Well, can you designate item 53 as the lead matter? It will be convenient to everyone. Please designate one matter as the lead matter, so everybody can file as per that. 53.
We can even have a joint
Nodal
obedience
council on each side
violation
can
over
be Mr. Fuzail this side and somebody from that side. So otherwise every batch will have different numbering.
That's it.
53 can be the lead matter.
Item 53.
Yes. And
item 53 was I shall remember so and so is ordered to be treated as the lead case.
Fuzail is the nodal council.
So and so land council is appointed as the model.
We'll give the name Aditya Sharma.
Aditya Sharma, my lord.
Right? It shall be their responsibility to compile the pleadings.
Joint convenience compilation. And the joint convenience.
And exchange the common convenience volumes.
Would my lords give us a figure?
Will it be all right if I list it after 3 weeks or 2 weeks?
If possible,
Because they are only from the angle of these young lawyers.
ripe, we should get it ripe.
Some documents, right?
Soon as between 2 and 3 weeks, whatever, I can't say anything.
Maximum it will be the third week when we'll list it.
Please, deeply, immensely grateful.
Deeply obliged.
I'm grateful, Manoj.
Grateful, Manoj.
The
Minutes.
Please.
और डिस्ट्रिक्ट गोंडा यूपी से आया हूँ। मेरी 2 सिविल अपीलें ऑनरेबल कोर्ट में पेंडिंग है और उनमें लिस्ट हो गई। महिला कितना दिन जिएंगे?
75 साल की तो उम्र कुछ भी नहीं होती है। आप 85 का बोलते तो हमें दुख होता थोड़ा सा।
दे दिया
तो अभी जवान है आप।
जी, ओब्लाइज महिला।
10 साल खूब अच्छी सैर कीजिए, खूब अच्छा घूमिए फिरिए।
ठीक है।
हाँ।
महिला
Make his lordship. Well, this is the only matter in which I have been waiting for more than 2 years.
It's great to spend this time hearing question. Just
this.
Standard order we are
I can only make a request to every court, my lord. We did that in the High Court.
Passing a standard order and that's helping everyone. We will pass the same order.
Well, my difficulty which I'm actually facing, a new advertisement in respect of the candidates have already been issued now. If it remains pending,
Same order will pass.
well, because
it is not maintainable. We are not inclined to entertain a repetition article 52 the relief for the grant of relief as per the distribution. How the petitioner shall be at liberty to move an application before the High Court and seek out of turn hearing of their case. We have no reason to doubt that the High Court will make an endeavor to redress the petitioner's grievances.
well, some time may be given in this. Well, some time.
No.
Well, item 26 the same.
24.
24 is also.
25. Will have to be transferred.
Yes, my lord. I have no objection, my lord.
Well, in fact, all the private respondents are represented by way of caveat, except for one party, who is the former vice chancellor of the deemed university.
Former respondent, my lord.
Well,
but he may not be now.
Yes, not required.
My lords may
not
transfer
required.
it. My lords may transfer it to Guwahati. My lords, that is my prayer, my lords.
So this transfer petition has been moved by state of Manipur. Seeking transfer of intra-court appeal bearing with appeals number 11 to 14 stroke 2026, which are pending before the High Court of Manipur. These appeals are directed against a common judgment and order dated 9th April 2026, passed by London single judge of the High Court in batch of petitions. And consult for the contesting respondents are in caveat.
Yes, sir.
Next, and consult for the parties jointly informed that there are only that beside beside the Chief Justice, there are only 2 judges.
Yes.
In Manipur High Court. In the High Court of Manipur, one single judge is the author of the judgment under appeal, whereas the other learned single judge has recused in the matter.
Please.
That being so, no division bench can be constituted to hear and decide the subject appeals. They have jointly requested to transfer these appeals to the Guwahati High Court.
Please, deeply blessed.
So, in view of the circumstances explained above and the consent by learned counsel for the parties, the student transfer petition is allowed and writ appeals number 11 to 14.
Yes.
Stroke 2026 pending before the High Court are ordered to be transferred to the Guwahati High Court along with the original record of the
of petitions number 486-501-633 and 495 of 2024, which were decided by the land single judge, while judgment and order dated, while common judgment and order dated 9th April 2026. Cancel the report.
My lords, my only request is, my lords, there are 3 contempt petitions which have been filed. My lords, till the Honorable High Court of Guwahati High Court decides on my interim application, my lords, those contempt petitions may be kept in abeyance till the application for interim relief is decided by the Honorable High Court.
Let the transfer court decide on merits, my lord. We are not, we are giving an undertaking that we are not pressing that contempt petition, my lord.
While the party shall be at liberty to seek appropriate interim relief from the Guwahati High Court,
please,
till such kind of like applications are decided by the Transferee High Court, the contempt proceedings seeking implementation of the judgment of the land single judge dated 9th April 2026 may be kept in abeyance.
I'm very obliged.
Let's say moving on to that content application, only for point is that let's say BC facility might be provided. Video conference.
Meanwhile, you can approach.
Once this order is there, then the Guwahati High Court may have some other opinion also, my lord. That's why I'm giving an undertaking that we are not pressing the contempt petition, my lord.
That is also equally good.
Yes.
That's not
fine. Till the interim relief का लिखा था last line बची change को तो land council for the private contesting respondents states that they will not press for continuation of the contempt process.
Yes, my lord.
Yes,
All
the 3 contempt petitions proceed. All the 3, my lords. My lords, would kindly fix a date before the Guwahati High Court so that everything.
Directed to appear before the Guwahati High Court on so date after 2 weeks.
My lords, can it be after 4 weeks so that because of transmission with
2 weeks.
2 weeks. Deeply
obliged.
Item 26.
I appear for the respondent. Please pass over this matter, madam. I'm seeking passover, my lord.
So, call quickly now, 3 o'clock you are asking for passover.
Lordship, in item number 27, a similar matter was listed during the partial court working days. I'm passing the orders copy. I'm requesting for the same, my lord. Can you please pass?
That's it.
Committee in the party. There is a committee.
किया था हमने जो
Yes.
I'm requesting for the same. Even in item number 51, that is also listed. Item 51.
27, 51.
I'm grateful.
Item 28, 29 and 42.
This matter concerns the language policy, my lord. Your lordships have issued notice in the other one. May I just tell your lordship, there are, on the surface, it looks like a simple issue. But your lordship's judgment has raised constitutional questions. So if your lordships will keep it early, because otherwise we'll be forced to ask for a stay.
But just verify meanwhile that have they issued some clarification?
Yes, sir. Yes, sir.
No, the problem is this, my lord. The problem is this, my lord.
They want.
This is 27.
So this is 27, 29,
42 also.
42 right now.
42 is notice is issued, but we want early hearing.
But we are arguing.
But your class 9, is it exempt now? Is it exempt?
Exempt for certain people. Only No, my lord, they are there
The
today.
issue is, my lord, the issue is this, my lord.
There today.
After notice is only.
After notice, some matters, my lord. Fresh notice now. Lord, the issue is this, they are implementing the circulars, which according to us are without authority of law. Because under the Act, Right to Education Act, the respondent number 2 has no authority. It's only the respondent number 3. Secondly, your lordships have held in a 5-judge matter that we have a choice to decide what language. I'm not on that, my lord, but they're imposing languages without giving alternatives. If I want to learn Punjabi, how will I learn it? There are no books available.
No teachers.
No teachers, no books. Only teachers and books are available for Sanskrit and Hindi. I am learning Hindi anyway. But if I want to learn Punjabi instead of Sanskrit, I'll tell you, Lordship, it's a very important issue, whichever side. But the question is, as a child, I must have an opportunity to learn a language which will give me employment at the end of the day. So there are important issues that arise, my lord. Either way, I'm not saying.
We had examined on the previous date of hearing. One of the concern was that if it is given effect immediately.
Yes, that's
then
right.
where are the arrangements made?
Yes, yes.
Now we are.
So there's some dilution.
It's
some people are happy with it, but I want to
some,
press.
just 1 minute, Shyam.
Yes,
There are
42.
2 different batches here. Mr.
One is
Cooper and I.
one is
we are-
6 and
we are
8.
appearing, just 1 minute. We are appearing in the fresh matters which are dealing with class 6 and class 5 who are affected. Mr. Divan's matters, which are the after notice matters, were dealing with the senior classes where there has been a dilution after your lordship's order.
Dilution is up to class 7.
Yes, up
So
to class
six-
9.
Is up to class 7. So
9.
your prayer may be, please extend it till the year each student gets the option to choose.
Correct. So just
People who are already in
give me
sixth
half
have
a
already
minute.
taken-
There are 3 fundamental issues. The first is the most practical one right now, which is that even in the replies that have been filed by NCERT and CBSE in Mr. Divan's matter, the state has said by 1st July, they've sent letters to all the schools. By 1st July, please ensure that all the books which we have already created will be available and will be utilized by all of you. We have checked even today, is in
No
middle of
books are-
July. Books are available in 3 out of the 22 languages. None of the other books are available. That is the practical problem why immediately there's no question of going ahead with this. The second is teachers, because their plan is that all 22 languages have to be available as a choice to every student. Your lordships can then imagine, because we have all been to school, we didn't have 22 language teachers in our schools. We had 3 or 4, maybe an occasional other language. 22 creates a complete impossibility of manpower for all schools in this country run by CBSE. That's the other huge problem. It's completely impractical. So it's entirely arbitrary. The third, and this is, I think, a critical issue which goes commonly to all the cases, is that they say that non-native languages are different from native languages. They've taken a 300-year-old language which is spoken in India, which is the official language of 5 states, English, and treated English as a non-native language. As a result of which, today you're telling all your students, learn Punjabi, learn Hindi, learn Sanskrit.
Not English.
Not English.
We don't understand this word native Indian
Exactly.
language.
Exactly. We don't understand it either.
Native Indian language may be understood as indigenous Indian language.
Perhaps, but as part of pedagogy,
Native Indian
Yes.
is a word which is loaded with a
clarify that English is to be treated as a native Indian language. Everything is takes care of it.
cannot be treated
So the Indian language.
spirit of the notification.
Yes.
It is actually carrying forward the constitutional goal of development of Hindi and other languages.
Other tongues
of
is the word that
India.
used.
No, there are, if you see the language
In the
articles,
constitution. Yes.
one word used is Indian language, another is mother tongue,
Yes.
the other is regional language.
Yes.
There is no expression as native.
No,
Indian
there isn't.
language.
There isn't. That's the problem.
What the authorities intended to do is, under the constitution itself,
Yes.
it's an inspirational goal.
Absolutely.
That Indian languages will take over the official lingua franca of the country.
Correct.
In doing that,
Yes.
maybe the encouragement is being made that you bring in
Yes.
and Indian language.
Correct.
The nomenclature may require some relook as to how do you use the word native Indian language. It may be something else.
Correct.
But the spirit is very clear.
Correct. So the problem now is,
Think with the spirit.
yes,
Can India consider English as an indigenous Indian language?
it's an Indian language as far as many of us are concerned, my lords. It's the official language of the courts. It's a language by which the constitution mandates interpretation of all statutes in this country.
Parsi at one point of time was the official language of the courts.
Yes,
Is
at one time.
Parsi a part of the 8 scheduled languages?
No, it's not. Neither is English. Neither is English.
Urdu was born in India.
Correct. Yes. Correct. So the choice is left to the states. Yeah. Schedule 8 is only for states to decide what their official languages will be out of that. Otherwise, it can remain as English. Constitution permits that. We are on a practice of many of our children.
Yes, I'm all set to argue my.
Yes, your point.
We are also set to argue.
Submission, and we'd like to place it for class 9 because there are certain, despite the dilution, there's a problem.
Despite this the clarificatory circular of 29th June 26.
That's right.
Your matter still survive.
Yeah.
Yes,
survive.
Completely survives.
Completely
survives.
The
dilution is very, very little, It does not solve our problem. Student of class 9.
4 petitions.
Not a student of class 9. One second, please. Not a student of class 9 who is studying, say, English and French till today is told that in 9th you take a third language, be proficient so that you can speak, write, debate and essay. In 9th, when you take up the language as if you are in standard 1 and you will give an exam at the end, my lord, of April.
New script.
Is the exam still written?
Sorry?
But internal.
No, 1 minute. An internal exam which is important. Unless you get a pass in the internal, you can't appear. It's all that way. How can anybody in the? It is not possible, my lord. And you say you had a choice of 20 languages. Which school in Delhi can give you a teacher, my lord, who can do, my lord, 20 languages? I mean, there is no infrastructure, there are no books, there are no teachers. And how does a 9th student, my lord, is 14 years old? He is looking at 11th and 12th. That's the burden he has to face. You tell him now, you start a third one, it is imperative. Can't work.
And it impacts on them.
And the whole.
It impacts.
The horizon was for 2030. The whole idea was to introduce this by 2030. Instead of that, they've advanced it to this year.
And you must start at an age when you can learn. Let's see what is possible.
Who was appealing for CBSE?
What is that? Which one?
1982.
Replies have been filed by CBSE and CRT.
They're not there.
I'm sorry, Malaj. I appear, but I appear in 42, Malaj.
42 is also being taken.
42 notice this issue.
Lordships, if your lordships may take it at 42, I will come physically and assist your lordships. Malaj, we filed it.
42.1, 3 and 4. It will take some time. So we are fixing a date for arguments and 28
Please,
and
my lord.
29 also, then you take notice, please. We'll tell your assisting counsel to appear in these two
Please, my
matters. Meanwhile, you can file your reply to these two matters.
But in the interim, my lords, let them not implement this in the interim, because the problem is teachers get dismissed who are teaching these subjects right now.
If anybody will be dismissed, we will state that dismissal.
No, but the students, my lords, we are students. There are 2 batches from grade 1. From grade 1, when they imbibe languages the best, till grade 5, they've already learnt 3 languages without teachers. I'm saying just let's.
They have issued a circular of 29th June.
Yes, which is under challenge.
These are mere guidelines.
No. They have mandated the guidelines now, which is 10th July.
If any coursive action is taken, please point out.
No, it's already there, my lord. 10th July. That's what is under challenge.
8, my lord, in my petition.
I'm sorry.
It's mandatory. They have to start.
I don't know if 10th July was shown to your lordship. 10th July now. Just give copies. 10th July is the problem. This is the latest one.
10th July is not on record.
It's in the NCERT, my lord's reply, counter in serial number 42.
It's in the CBSE affidavit.
I don't have that affidavit. Yeah, I know.
It's
They
at
have
page
the
32, page 32 of the CBSE affidavit.
Yes. This, the CBSE is filed with theirs. This is 10th
counter.
July. The directions are class by class, your lordships will see. As far as we are concerned, it's at the third page. Students who are in class 6 at the bottom, D. Out of 3 languages, 2 would be Bharatiya Bhashas for this batch and onwards. When this batch and subsequent class 6 batches progress to class 10, they shall take the board examination of R3, this new language, which is a substitution language. The dedicated R3 textbooks for class 6 in 22 scheduled Bharatiya Bhashas are being made available on so and so. We've gone to this NCERT website 20 minutes ago, and there are only 3 books, not 22, 3. This is what they have sent to all heads of CBSE affiliated schools as late as 10th July, claiming that these textbooks are available, telling these children to now drop both English and the foreign language that they have and take these 2 Bharatiya Bhashas.
No, but there is no such mandatory that you will not be admitted to school.
No, not about admission. No. When they're in school, they're going from 5th to 6th. They're being told that now the languages that they've learned for 5 years are gone. These 2 new languages you have to be taught.
Nothing has gone.
That's the problem.
The learning of language never goes waste.
No, that's not the point, my lords. Your lordships have seen, infrastructure-wise, as per their own affidavits, which they have filed, they have said unequivocally that by 1st July, the textbooks will be ready. Admittedly, it's not ready. It's not ready. It's not their statement that it's ready. Secondly, they've said teachers have to be ready for 22 languages. So all children have to have this available to them. This is a damaging status quo.
My lords, we'll file a reply, my lords, within 2 weeks. We have already filed a reply qua 9.
10 days.
My lords,
10 days we are listing exactly after 2 weeks.
lordships, please.
On a Wednesday, would
We'll
you
file it,
like to
my
put it on a Wednesday, Thursday?
Yes. Lordship, I issue notice in the other matter.
We should notice accepted also. Notice accepted, reply within 10 days.
Very well.
And then post the
Can it be listed immediately after that, no? Any date?
Wednesday. Coming Wednesday.
Coming Wednesday. Very well.
Right?
Wednesday.
10 days.
Wednesday week, no? Wednesday.
Wednesday week. Very well.
22nd.
We'll take it up. We mentioned it. We're all here. Those are small things. Very well. Very well. Very well. Very well.
Take mic, and in this very matter.
Yes, my lords. I am representing former Rajya Sabha Member of Parliament, Madam Fawzia Khan, who has also been the Minister for State in Maharashtra. So she's also handling a lot of minority schools, and she heads a organization in this pretext as well. So, my lords, I have...
So this side or this side, first of all?
This side, obviously. So because I didn't have space that I have come over
No
here.
space given to you.
Not the mic, the space.
Obliged, lords.
You can assist us on that day.
Yes, my lords, and there's an intervention petition that's been filed in our regard. I just request
Really?
one more prayer which I would want to, add on to what has been placed, my lords.
Nothing in piecemeal, nothing in piecemeal. There's composite argument on the date.
Because this has really hit hard on the mental health of the students, particularly in the downtrodden space. So we would want that also to be taken care, because mental health, the only solution that we can ask is from the Ministry of Education. So may not be stress from the Ministry of Education for the children. Yes.
Thank you.
Thank you.
Case item 30.
This is your seeking a lordship's intervention for the purpose. May please, my lord. My lord, this is seeking a lordship's intervention for the purpose of lordship the rampant and... Yes. 130. No. Well, just have... Pardon, my lord?
Notice Dasti.
Please, my lord. Please, my lord. My lord, one more request. There's only Bar Council of India which is being made a party. May I request for addition of the other party? State Bar Councils and the... My lord, I do that. I do that, my lord. Oblige, my lord.
Item 31.
Please.
My lord, sir.
Lordship will file
10 FIRs are registered in the same police station.
What can we do, Muslim?
Because same police station, the judge says the name of the police station is SOG. SOG is the name of the police station. The learned judge says, Milord, that you apply to the police station for clubbing.
My lords, completely
How can you apply
beyond
to the police
jurisdiction,
station?
the Honorable Madhya Pradesh High Court has passed the order. When the cases
Please
are
allow us to
pending in
make our-
Rajasthan, and the order has been passed,
have
my
a
lord,
look at
and
the
if your lordship will see the magnitude of the
Maybe
order, everything has been
My
stayed.
friend must
And this
allow-
was also being done at the order of the High Court of Rajasthan, my lords. And still,
Kindly turn to para 9 below.
not,
Para 9 below.
if
Page
your
6. Para 9, page 6. Further, from the factual report, it reveals that FIRs are not related to one offense. Beneficiaries are different. So is the cause of action. In that view, prayer is not acceptable.
Everywhere the question of quashing the FIR.
No, forget it. No, Milord, I'm saying club. Clubbing.
No, if they are in the same police station, these can be clubbed.
That's all I'm saying. That's all I'm saying.
No.
But
See further, Milord. See further. It is clear from the record, petitioner is not.
my lords, I am appearing for state of Rajasthan. It is a special operation group, my lord, of police, my lord, which was directed by the Rajasthan High Court to register FIR and investigate.
Right.
Now, my lord, against the university which has been selling fake degrees, my lords. Now, when the court issued warrant, search warrant, and pursuant to that search warrant,
can it
when
be done?
the
Suppose
police
can
from
it be done only to this extent that if the 10 FIRs are in the same police station, then there can be same common SIT for investigation so that there are no conflicting outcome also.
My lords, if I could clarify, my lords, item 31 is by the accused, my lords. 31.1 and 31.2 do not deal with clubbing, my lords. Learned senior is appearing.
Just let
That's different. 31.1, you separate. So, as the Chief Justice said, Milord, one police station, 3 charge sheets are already filed. I am arrested in 4 cases. I am bailed out in 2. The fear is that you will, once he is bailed out in the remaining 2, you will put an arrest in the second one, 6th one, 7th one, 8th one. They are all before the same court.
No, if that is so, let it be. What can we do? Because if you are arrested and you are indulging in this kind of mass.
That's the allegation, Milord. That's not true. But anyway, let it be clubbed in one police station. Milord. Same IO.
not in the
Same investigating authority.
not in the manner, my lords, my learned friend
I
is
know he's the
proposing.
complainant himself.
What is the factual
My
position?
lords, in 31.2, my lords, we have been doing investigation, my lords.
Please talk about our case.
Sir, IU is.
Mr. Sanjay,
Lordships,
can you constitute one SIT for investigation of all the 10 FIRs? That's all.
my lord, I will seek instruction, my lord, on that. But so far as these are different transactions, my lords, now for with respect to different examination.
We are very clear. There is no question of quashing 9 FIR and allowing one to survive.
Lordships.
That is one we are very
Lordships.
clear. All 10 FIR pertain to different victims, different circumstances, different incidents.
Lordships.
These will constitute 10 different
Lordships.
offences. But with a view to ensure that you also don't face tomorrow difficulty, let there be a common SIT so that conclusions are not conflicting at variance.
My lord, so far this 30, the first case in which my learned friend is appearing, my lord, the instruction will be speak, my lords. Now, so far as 31.2 is concerned, my lord, in that case, the state of Rajasthan is before your lordships. If your lordship will kindly have pleasure to see 31.2 in. So
My lords, so far as
Lordship
item
may-
31 is concerned, my lords, it's a fresh matter. We're not even
हाँ.
appearing on advance notice, my lords. My learned senior, my lords, he is appearing in 31.2, my lords. So your lordships, if your lordships are issuing notice, your lordships, you
हाँ.
can confine it to the notice, my lords.
Your
We
lordship.
don't even have a copy of the SLP.
Lord, in my case, out of 10, 4 charge sheets have already been filed. So I have no problem. The Lordship may constitute one SIT. Let it be in one police station. I will apply for bail in all. I have no difficulty. But it can't be, my lord, that IO is the complainant himself in 6 cases. What he does is he records the statement.
What the prejudice to you?
My problem is, IO is the complainant in 6 cases. What he does is, he is recording a statement in FIR A. Based on that statement, he records FIR B. Then he records another statement, records FIR C. Anyway, he has done 10 of those. I am only still arrest me in others also. I will seek bail in all of them, but club them at least. What is the purpose of each individual?
No, this clubbing has been, this expression club has been with greatest respect completely misunderstood
Consolidated
by this court in many
Grateful.
cases. We don't want to
Grateful,
repeat
my
that
lords. Grateful.
mistake.
We don't consolidate.
Why there should be an accused-centric approach? What about victims?
I know not accused central, they are all in one. I am not asking for any transfer of any FIR. They are before one officer, one police station. You can consolidate them.
You can have instructions that can there be a common SIT
They can.
for investigation of all the cases.
My lord, that in that case, notice has to be issued, my lord, because my learned friend is appearing in 31.
My lords, we
My
don't
lord,
even
I am
have
not
a copy
appearing
of the SLP, my
presently.
lords. We don't know what the matter.
We don't have a
Has
copy.
been
No
wrongly
notice has been issued as yet, perhaps.
Issue notice for the limited purpose as to whether a common SIT be constituted, can be constituted to investigate all the 10 FIR.
11
FIR. Then say, you accept notice for state.
Yes, my lords, I'll do that. my lords.
Then, Madam, go accept notice on behalf of the state, post on so date to have instructions. Just
Please, my lord.
instruction for limited purpose.
Please, my lords, because we've not even seen the brief, my lords. We don't know what item
Ah.
31 is, my lords. If your lordships could simply issue notice, my lords, we could respond to that, my lords. If your lordships could simply issue notice, my lords, because we have not seen the brief also, my lords, for item 31, my lords.
Have instructions, madam, otherwise it will delay unnecessarily.
My lords,
In order we have to pass.
Take instructions. We will take instructions.
Can I request an
Now,
earlier
what is
date?
No, my lord, so far,
31.1?
My lords, an earlier date, my lords, if it's possible.
again, 31.1, my lord, is a fresh matter, my lords. We are not aware of that.
31.9. My lord,
How anticipatory bail has been granted?
I am appearing for the state in 31.1. Lord, I am appearing for the respondent.
This fraudulent order is obtained.
My Lord, in fact,
Yes.
this
Absolutely.
was Lord,
Unheard.
jurisdiction in Lord, FIR quashing petition. The protection was only up to 19th of May, and thereafter, my Lord, of course, I was permitted. I joined investigation.
Uttar Pradesh and Uttarakhand, you are committing frauds while sitting there and
But I'm not, this matter has become infructuous. Thereafter, I applied for anticipatory bail that has been dismissed. Now, of course, I will avail my remedy in accordance with law. This protection was.
in view of the fact that the respondent's anticipatory bail application, petition for grant of anticipatory bail has been dismissed by the jurisdictional high court.
My Lord, it is the district court. My Lord, may kindly dismiss it because the protection was up to 19th of May. And 19th of May has gone long back. Thereafter, I filed. Thereafter, it was extended up to 7th of June.
April 2026, interim protection against arrest was granted to the respondent.
Up to only 7th of June, my Lord, ultimately it was.
7th of June 2026.
That has, my Lord, already left.
Period has already expired.
Correct, that's right.
However, the order being palpably illegal, we direct that no further protection shall be granted by the High
This
Court.
will come in my way of even seeking anticipatory bail. My Lord, that issue is already over. If separately, my Lord, want to say something
No,
to the.
you can, but not in this matter.
My Lord, I say I have already, my anticipatory bail was dismissed by trial court.
We are only saying if tomorrow you will file application in this very case, that instead of 19th,
I'm making my statement, of course, because I have already filed regular. Lord, this was quashing. Quashing was disposed of. Lord, this order may not affect my bail petition, which I'm likely to file in the High Court.
This order, shall have no bearing on the merits of the
Application filed by the respondent before the High Court.
Item
31.2.
Lordships. Now, so far this case is concerned, in most illegal manner, even without jurisdiction, the High Court of Madhya Pradesh has granted interim protection to the accused persons and has restrained the police even to take the investigation, even restrained from investigation in the university which has been selling fake degrees, In 76 cases, their fake degree has been found. So, fresh matter, we need notice and stay of this order.
Meanwhile, operation of the interim order by the High Court of Madhya Pradesh, interim order dated 10th February 2026 passed by the High Court of Madhya Pradesh state.
Grateful, deeply grateful.
Mr.
31.2.
Vikas Singh, it should be listed before Justice Sanjay Kumar.
Only difficulty is not that I can let it be listed tomorrow then.
Tomorrow.
DPW.
In view of the fact that the bench is executed by PV Sanjay Kumar J. Tomorrow कल की date है
DPW.
The committee has submitted the report, my lord.
Mr. Fulka, in this matter, the committee has done a commendable job.
Yes.
And have you been able to?
No, Madam, we have not. We don't have the such.
With us.
If we could, we both are
Online now, my lord.
mostly pairing for
That they were waiting for our formal approval.
It is available on the web.
Grateful if this report can.
Pursuant to the order restriction, so the experts committee chaired by Justice Aniruddha Bose, former judge of this court and director of National Judicial Academy, have submitted a handbook captioned as inverted comma judgments and gender, again in brackets sensitivity and compassion writing judgments, which is taken on record and approved. The same may be uploaded on the website of the Supreme Court as well as all the high courts. In case separate websites are maintained by the district courts, the same shall be uploaded on the website of the district judiciary also. The aforesaid handbook shall be published on the websites of the National Judicial Academy and all the state judicial academy. The same be also circulated to all the national universities, state universities, in law department in all these states. Do we have extra copies of it or soft copies?
My lords, it is actually uploaded on the e-filing website. Of course, I saw it's on the e-filing website. If you're a party in the case, it's there. I have a soft copy. I can share it of the report. It's on the e-filing website already.
of the Supreme Court, my lords, the report of the National Judicial Academy.
No, on the website is only this booklet, this text.
The MA, because it's called the item today is numbered as the MA. So the MA at the bottom of it has the soft copy of the entire, the PDF. I can share it because we downloaded it from our e-filing portal only. I can, the PDF is available.
It's a separate link.
Please show to the secretary, Madam Kivabe.
I'll also share a
If your
PDF.
lordship,
The order in which my lords have actually interfered, not exactly similar order now has been passed by Patna High Court, my lords. Similar allegations, similar observation. I'm just handing over to my lords for the purpose of record. I've marked the pages and the para number. Unfortunately, despite my lords have taken cognizance of that order and set that aside.
This is before that or after that?
Now, 9th of July, my lords.
well, unfortunately, in many cases, the victim has to go the trauma second time in the court.
And that was heavily reported, my lords, when my lords have taken cognizance and set aside that order. The report has come. I just showed the diploma. In fact, despite observing that 354 is made out, which is incorrect view, they have not even punished that accused for that. Names the routine duty.
Para 26.
Yes.
Was my judgment cited there?
So after believing the complete version of the prosecutrix.
This judgment was brought to the notice of the High Court?
No, this is High Court's judgment now.
No, the judgment passed by this court.
It's now its latest judgment, it's 9th of July 2026. We have just noticed because it was reported in fact, it was reported in the social media website and we just
We are not the lawyers there, my lord. It's the public prosecutor, my lord, who is handling the matter.
but troubling part is it is happening every now and then.
Yes.
Not cited.
No, but that
It was not even brought to the notice, my lord. It's a public prosecution. And the court should know it.
That is the tragedy actually, that if you don't cite the judges or their of staff, they don't do any homework. That is what the tragedy is, that otherwise it is not that you always expect the parties counsel to cite it. There is a duty cast on the judge also. He should also
That's true, my lord. That's true.
law, understand it, that how it has been interpreted.
Madam, yes, rest.
Approach,
Madam, this,
similar approach.
this report may be made a part of your lordship judgment.
Yes.
Then it will become binding and then it will have to be followed. Otherwise, it will remain advisory only.
This word also is
Can be reproduced in the judgment itself.
it is directed that all courts in the country shall strictly follow the expressions contained in the handbook approved by this order.
And the director prosecution, we directed to circulate it to the court problem prosecutor.
Of all the states are also directed to implement this handbook and issue instructions to all the police stations.
Police.
Director prosecution, director general police and director prosecution to issue instructions, necessary instructions to all the police stations to follow the contents of the handbook while recording an FIR.
Please, madam.
While recording an FIR or filing a charge sheet.
Please, madam.
Filing a charge sheet.
Very grateful.
Madam, this is a part of the judgment, madam, like an extra of the judgment.
Yes, they will become part of the judicial.
That's right.
We are very grateful for the.
So grateful, madam.
We what we will do, we are also, this is only operative part. We will deliver some, a reasoned judgment.
So grateful.
We will deal with this judgment also, remind me, Patna High Court.
Very grateful.
So grateful.
Thank you very much for your assistance in this matter.
Please, your lordships. Lord, here,
I am for respondent number 3, the complainant.
an order has been passed. Please have a look,
KVL.
Lord, at page 272, 232. This flies in the face of barium chemicals.
Item, you are talking about item 52?
52.
Correct.
52. Lord, this is an order appointing an auditor. And for this statutory auditor, you are required to report reasons. Barium chemical says that. You get jurisdiction to do it only if you record reasons. No reasons are recorded. Now, please have a look at the order, Lord, 232. These are the allegations, Lord, which have been reproduced. After reproducing the allegations, 233, straight away, without recording any findings, without recording any grounds. The word audit is missing. The word audit also is missing. And straight away, my Lord appoints. Now, please have a look at the barium chemicals, what your lordship said. Now, and now, Lord, what? Sorry. No, we are not just afraid. Look, this is obviously a political precursor to taking over the association. There is nothing else. What happens is, please see this, Lord, what is worst is not only the High Court.
Mr. Nadkarni, let the auditing be done. The report will be produced before the High Court. And we can request the High Court that the High Court.
Lord, we have already done the report. The ground on which they manufacture is that you have not submitted the audit report. Whereas Advocate General concedes that a report is given.
It's a question of.
Please, Lord, please see 272. Please have a look at 272. Report is given. Please see 272.
See, these are the matters where some efforts of institutional transparency is being.
Lord, we have absolutely no doubt they can pass a fresh order. What I am saying is, barium chemicals, your lordships have laid down the law, identical provisions.
Mr. Nadkarni, only for directing auditing, the High Court has already written 22 pages.
Lord, High Court has gone completely haywire. Even Lord Mohinder Singh Gill, Gordon Das Manji's case, you can't allow High Court, Lord, you can't allow government registrar to supply reasons in a statutory order. It makes a mockery of the whole judicial proceedings. With great respect, Lord. Please have a look at what the High Court has done.
No, High Court, one reason by the High Court itself is sufficient, para 17.
Yes, that is itself contrary to the record. That itself, please see page 272. Advocate General considered that yes, we have got the report. The whole file was produced. Not just the first page and the last page. The whole file was produced.
Whereas
Lord, they can pass a fresh order after taking, but not this way.
No. It's not that you have not been heard at this stage.
No, it's not the question of not being heard. Lord, I was heard But it's a wrong order.
Was there compliance of 12C?
Yes, we have complied.
No.
That's what, and that is 272.
You have complied?
Yes.
Or before they complained or after the complaint?
Before,
Para-10.
in time. Please see the receiving date. Please have a look at the date. Lord, please have a look at the date. But this is obvious, Lord. This is politics. This requires your lordship second look, Lord. 26 November it is filed.
Completed, number one, we will request the High Court to, after the report is, or the audit report be placed before the High Court in these very proceedings, and whatever follow-up action is required to be
High Court has
taken.
disposed of the matter.
It is before, my lord, let me
Lord,
tell your lordship. This is, just let me tell your lordship, 1 minute. My friend is making all kinds of submissions.
No.
This is the Goa Cricket Association. Now, I am a life member of the Goa Cricket Association. These people have only come after the election of 16 September 2025. My complaint was pending from.
He is the one who has
14th
lost the election.
Just 1 minute. My complaint is pending from 14th August 25 against the earlier committee also. No action is being taken. I go to the High Court saying no action is taken. There is no audit report. Page 272, what he is showing is one covering letter without any report.
The full report.
Just 1 minute, please don't interject. Now, therefore, the High Court in my writ petition asked the Advocate General, what are you doing? Advocate General says the Inspector of Societies is looking into the complaint. He will take action within 6 months after hearing everybody. They are issued notice. They come on notice and they take objections. Papers are stolen. This is stolen. The auditor says, where is the report? Please show me the report. They have no report to show to the auditor. So the inspector says, all right, I will ask the chief controller of this. If your lordship sees the order.
In fact, there's an affidavit where he produced papers
just
which
1 minute.
nobody has.
He has asked the,
He's the one who has
office
stolen
of the district registrar and the chartered accountant to depute 3 accountants to audit their accounts. He says, once the report comes, I will hear all of you and pass an order. Now they are running scared of that. They don't want their
we are
accounts
not running
to be audited.
scared of that. We
This
are on
is
the legal point here.
Completely. And just see,
How
what
can
the,
you?
just see what the High Court records. Please see para 10 first of the High Court judgment.
Lord.
All this is wrong. Then go and file a review before the High Court.
No. Why review?
This, just kindly have para 10 of the High Court order. Please have para 10. Para 10. 10, 12 and 13. 3 paragraphs. Para 10 is at page 15.
That's wrong. That is what I'm challenging here. You can't allow the High Court. The High Court can't allow them to produce reasons like this.
The real concern or the satisfaction recorded is that there was no audit compliance.
Correct.
In terms of section 12C.
Correct.
And therefore, whether irregularities, if any, to be reported under 12D.
Correct.
And because of that, and now if that is correct, the jurisdiction is well taken.
Correct.
But it's well settled, not only barium from anismini.
Correct.
When the question is of a jurisdictional fact,
correct,
we must see whether the foundation of the jurisdictional fact.
So please see para 10. Please.
What Mr. Nadkarni is disputing is that this finding is false.
He has to go and file a review then. Please see para 10.
Lord, show us one line.
Just
let them show one.
let me read para 10, my lord. My friend
is not there.
He doesn't want me to read
This
it.
requires consideration.
He doesn't
by
want.
lordships.
He doesn't
High
want.
Court has made a mockery of the whole thing.
By shouting, it's not going to help him. Please let me read para 10. Please let me read para 10. May I read it, my lord? In the present case, the registrar's original file produced by Mr. Pangam clearly shows that the petitioner placed on record a covering letter addressed to respondent number 2, accompanied by a 1 page of the audit report for the financial year 24-25. The Inspector General was never furnished with a copy of the complete internal audit report. there was no compliance with sections 12C and 12D of the Act. Pursuant to this court's order dated 3rd February, respondent number 2 was bound to complete the inquiry within 6 months. Thereafter, respondent number 2 issued notice to all the parties who have filed their reply. He considered the objections raised, and those objections are there. Then, if your lordship will have para 11, they reproduce the sections. Then come to para 12.
Please, the High Court gives it for the first time.
Please, Mr. Dhankani.
Sorry.
He doesn't want me to read it.
Apology.
Make your submission.
He doesn't want.
Please see, Mr. Patwalia, what is weighing with the authority? One, that there was a High Court order for consideration of your complaint. Correct?
Correct.
Then the objections raised by Mr. Dhankani's clients are threefold. One, respondent number 3 had not disclosed the source.
Correct.
Forget about that. That
Correct,
is
correct,
immaterial.
correct.
Second, there was no audit report.
Correct.
Before respondent number 2. Now, this is disputed by them.
Then he must file a review. So, High Court is giving a finding. There is
what we are saying. This finding on the record appears to be an incorrect one.
No, my lord, just see what.
Fact.
My lord, just see what he has now. Just see page 272. What he is now filing.
272 is my acknowledgement. But there's something.
But why should this? This is a public body. Body be shy. They are not.
No, it's not a question of
giving accounts.
Law should.
For both of you, say, I will understand the concept of the party. The High Court has wide influence order merely directed the fresh audit of the accounts of the fresh audit accounts of the petitioner association. Once the auditing, once the audit is complete and report is prepared, let such report be placed before the High Court. In the audit proceedings which have been disposed of by the influence judgment, the High Court is requested to revive the proceedings for the limited purpose of hearing both sides with reference to the audit report that is to be submitted in compliance with the High Court direction.
Whether there was an earlier audit.
The petitioner shall be at liberty to urge that there was already an audit report strictly in accordance with the
section 12C.
12C. In accordance with section and 12D of the so and so Act.
Yes. But the audit report shall not be acted upon till the High Court decides the matter.
Of the audit report, the consequential action pursuant to the fresh audit report shall be, if any, shall be only after hearing both sides.
Grateful. Very grateful. Very good. Very good.
Registration Act 1862.
Very great. Great. So everybody goes happy.
Sometimes we have to use that magic wand. Item 9. Pass over.
Yes, ma'am. I'm appearing. Followed in this matter. He is facing the trial.
Hello, yeah.
My lord, I am behind the bar more than 9 years, my lord. And my lord, I have been acquitted in 5 of them. One of them I have been convicted of 6 months, my lord. My lord, I am running to post in this matter, my lord. There are different states, my lord. I am required by way of this.
So you went and collected money from those states.
My lord, it is not a fact because I have a bad return, my lord. I am ready and willing to whatsoever they are claiming. I am ready and willing to settle this.
Get your anticipatory bail in this case.
My lord, I am behind the bar. My lord, I am behind the bar.
Behind the bar, this might be to bother.
My lord,
you are in safe. You are not behind the bar. You are in safe custody.
My lord, I am.
You are a very invaluable asset for the nation. You must remain protected.
My lord, I have not siphoned off the money. My lord, these are all complainants are my agents, my lord. My lord, my lord, all agents are, all are my agents. These are not the end user, my lord. What they have done, and my lord, they pocketed the money. My lord, I am ready and willing to settle down. I'm ready and willing to, is it so?
No case to grant the desired relief is made out, dismissed. However, the petition shall be at liberty to approach the jurisdictional high courts for ancillary relief.
My lord, I have approached to them. One of them had declined, my lord. I have impugned, I made a, my lord, there is judgment of my lord, there are judgment of, on the two aspects, my lord. There are one judgments.
We are, you know very well, every day we pass this order.
My lord, 8 to 9 different places are there. Nobody is there to taking care of them, my lord.
Thank you. Thank you very much.
My lord, may I suggest, my lord, may I suggest, my lord, kindly direct the concerned High Court to consider on the same day. I will be moving on within a week, my lord. If I am moving.
You can approach the High Court, that's all we have.
My lord, so much time they will take, my lord. Already 9 years down the line.
You repay the money.
But I haven't
taken so much of time to repay.
My lord, I was bedridden. Sleep. This problem was there. My own agent they pocketed.
You were in state custody, so your health.
My lord, I have been acquitted. My lord, if suppose they are going to, if suppose most of the matter I am going to be acquitted, there would be not possibility to set the clock back. Who is going to, my lord, return my this particular times, my lord?
Who is going to return the investors' money?
I am ready. Let them sit. They have confiscated my entire property, my lord.
For that, you can always file an appropriate petition.
My lord, may direct the SEBI also. My lord, may direct the SEBI. My lord, Bapkar's matter, my lord, have also done in that.
No, these are the relief in this petition. We will not grant. We will not entertain this kind of petition. If you want to withdraw, you can withdraw it.
Very well, my lord. Then I am withdrawing this, my lord. I am withdrawing it, my lord.
Like, after arguing the case for some time, learn counsel for the petition, seeks and permitted to withdraw this petition. With liberty to seek appropriate remedies before appropriate forum.
Only 30s are there. Most of the matter I have been enlarged on bail or I have been acquitted, my lord.
You can settle those matters.
13 are remaining.
Item 26.
Very well, madam.
Pass over item 26.
I am for the respondent.
There in the first round. My apology, my lords.
Madam,
My lords were very kind.
despite our suggestion,
yes,
we indicated this man appears to be over clever. He is more than a professional. He appears to be little more than that.
My lords, he's approached the High Court. The matter's not getting cleared because when he went to Karnataka.
Why he didn't approach the Madras High Court originally?
My lords, he went.
Why he didn't indulging in form shopping?
My lords, today he's already filed before Madras High Court. I'm only asking for extension of this protection.
Today itself, let him first surrender and go there.
My lords may give him. My lords were very kind. My lords, please grant him some.
Conduct of, and particularly a person who knows how to wear robe. If he indulges in this kind of malpractices, what we expect from the commoner?
My lords, this is a case where, my lords, for him it was a professional brief, and I'd shown he had filed that whole list. My lords, may just say that for the particular period, let him get that listed. It's only the problem was it isn't getting listed. My lords, may just extend that protection.
No, madam, his conduct doesn't warrant. He appears to be little over clever.
My lords, may I just say that now the problem is this. Karnataka took a view that it didn't have a jurisdiction, and now the registry. And my lords, today the registry in Tamil Nadu, the Madras High Court is also not listing it because they say they don't have the jurisdiction. No. But that is for the court to decide. Naturally, the registry can't take a call on that. But
yes, correct.
My lords, can I make only this request to my lords that my lords may give him 2 weeks from today? After that, my lords, whatever it be, then that is so be it. My lords have been very kind. My lords granted that protection for.
No, we had granted protection, but he misused our protection.
But be that as it may, even it is that he filed before the High Court before the period was over.
If a person can misuse the orders passed by court number 1 of the country,
my lords,
then what we expect from him?
My lords, he approached Madras High Court before that period was over. He approached Madras High Court on 25th of June before the period was over. Unfortunately, it couldn't get listed. That's all, my lords. I'm therefore saying that it is not that he went beyond and we have come. He filed it on 25th of June.
Sorry, you try your luck.
Between 16th, when my lords passed an order, 18th, Karnataka High Court, 25th June, he had filed it before the Madras High Court. So I'm only requesting, my lords, please grant him that protection.
No, please go and request the High Court. The High Court will hear the matter and pass an order. You can.
My lords, I'm only saying 2 weeks, and I'm not asking for too long.
You can-
Only 2 weeks, I've already filed it.
No,
I've already
not
filed
grant
it.
even for a day, please. This kind of person has no sympathy with.
Grateful.
Item 34.
Obliged.
Worship, I appear in 34.1.
We will take up on some other day. There is no urgency in this matter. Item 35.
Please, Your Lordships. Lord, it is a 1.5 lakh crore scam, my Lord. 1 lakh investors, 10 states involved, 8 years have gone by, accused are roaming free. The asset recovery is only 400 crores. This is why we were compelled to come before Your Lordships under Article 32. Requires a special investigation team.
Not the public interest. You are alleging a particular non-compliance of an order of the court.
No, my lord.
Yeah.
That's what your lordships had suggested that am I? Because during the vacation when this matter was posted, your lordship posed a question to me, is it a contempt? Where I had clarified my position, my lord, that the order at page 281, where your lordships can...
Then there is no clarification on the court.
Your lordship posed a question orally, my lord. I'm responding.
Yes.
My lord, your lordships probably were concerned with the order at page 281, where this honorable court cancelled the bail and said, let the accused go and face the music, and directed the CBI to consolidate all the FIRs at their discretion. So my grievance is not that whether they have consolidated or not. Unfortunately, they have not. But it is their discretion. Even if I move a contempt, they will come in the technicality that we are exercising our discretion. Have no statutory mechanism to protect the victims. Today, there are 7 petitioners before your lordships, but there's a list of 300 people which have enclosed. We have formed into a society. If your lordships are inclined to interfere, we would like to obviously implead and assist also. The people at the list are 300 people there, my lord.
I beg to appear, my lord.
My lord, the order.
The
Your lordships have issued notice in 35 minutes.
Yes, sir.
Your lordship may kindly make it returnable, my lord. 8 weeks. Returnable notice, my lord. Because there's ongoing siphoning. That was the concern.
It is always there. We never issue notice.
Deeply obliged. Deeply obliged.
My lords, this is an
Immediately notice and speak. And so on should wait.
I'm great.
Meanwhile, operation of the influence judgment shall be mentioned.
Very grateful, my lord.
Please, ma'am.
This is
Lord, they got
pending as being tried.
Yes, ma'am.
Yes,
ma'am.
go to High Court.
Yes.
He went there, but his case is not getting heard. That's the only thing. He can't take a
My lord, this court already settled the issue, my lord.
The matters are pending in High Court. You can become party there.
Lord, now construction work is going on.
So what?
We have not the civil court to grant exemption, please.
Then give me liberty.
There relief also you can ask for the High Court.
Then give me liberty, my lord, so I will be, I withdraw.
The High Court, jurisdictional High Court, along with prayer for interim relief.
Yeah.
With the liberty of government.
It's not already approached, sir.
If others have got it.
Yes.
His case is not being heard.
Since the petitioner has already approached the High Court, he may pursue the matter, he may pursue the pending petition. The entire relief pending may also be placed by him in the pending proceeding.
Look, in this pending matter, respondent is not a party. This is the difficulty.
You can always say, amend it, you know very well. If you want to
I
add
will
in
file a fresh writ petition because this is a fresh cause of action. So I will, I withdrew it and I file a fresh because this is the, yes.
Yes, item 38.
Wait, please, my lords. My lords, I'm only aggrieved by paragraph 44 and 47.
But tell us what is your explanation? You are passing orders against it, you are decreeing suit against a dead person.
That is by my predecessor. That's an Exhur P7. I have not passed that.
How did the dead person appear before you?
No, my lords, he had never, that suit was decreed by my predecessor. My lords may kindly see an Exhur P7.
Your only argument is a judge can.
No, my lords, my most respectful submission.
Of a nullity. This order, the decree is a nullity. That cannot be the foundation of a subsequent decree.
My lords, it wasn't that.
If your order probably is not by you, is what you
It's
are
not by me. So if my 6th copy, so then
Decrees by you only.
no, that's my lords. My decree is 13th May.
Is 115.
Yes, my lords, 13th May is by me,
Huh.
and my lords may kindly see page 112 of this order. Why I decree this? Now the person who has a decree in his favor, whereby the
argument is that the vehicle in front of me was being driven on the right hand side, and therefore I will also.
No, my lords, that's not the point. The point here was, what I said was, I said, if you say the decree is wrong, go file an appeal, set it aside. But till the time the decree is set aside.
That's a preposterous proposition which a judge cannot even contemplate.
My lords, may I please request my lords to have the reasoning?
So if the facts are brought before you, pointing out that the earlier decree is obtained by fraud, are you?
My lords, I cannot sit in a
good spectator. Are
my
you
lords, but I can't sit.
Serious in pursuing this argument before us?
No, my lords, what I.
We are asking a question.
Yes, my lord.
Are you serious in pursuing an argument that in a collateral proceeding there cannot be a declaration that a decree is void?
No, my lords, that's not my argument.
That is not your argument.
My argument is twofold.
If that is not your argument, then the observations are absolutely right.
No, my lords, may I please point out two things? My foremost argument and respectful submission before my lords is that I am not saying that this judge is infallible. I am really not saying that. There could be an error in judgment, but whether that is enough to have this disciplinary proceedings initiated against him. If there is an error in judgment, that could have been set aside.
We just had another of your friends arguing that a conviction under outraging of modesty, when an attempt to rape ought to have been the logical conclusion, is so egregiously wrong that we should so much to intervene.
No, my lords,
If that is the standard of arguments advanced in respect of judicial knowledge and expertise,
my lords,
would you apply the same test in your case?
No, my lords, I am not at all. I'm not at all that. I'm not even at once saying
that. Then you should withdraw this petition.
My lord, kindly see page 112.
You do one thing.
Yes, my lord.
You please go to High Court, file an application seeking recall of the observation made in para 44.
My lords, what I understand is that he had already done, had spoken on the administrative side, but since the order is passed on the judicial.
You can't speak to anyone. You have to, this is a judicial order. You need to go and seek this ratification on
I'll
judicial.
do that, my lords. My lords may permit me.
Ratification, maybe you are still not likely to be exonerated, but the degree of your misconduct might be.
My lords, what I may most respectfully submit, it could be so that his judgment is absolutely erroneous. That I am not even for once supporting that what he has written is correct. But the only argument is neither of the parties, not even the party who had filed the appeal, has at even once at any point of time said that this was absolutely incorrect. Perhaps something could have been done on an administrative side. Perhaps even something could have been.
That's exactly what is being done.
No,
It has
that's
been
not. My
referred
lords,
to
it's being
the
done on the judicial side. He is being discredited.
He has been
My lords.
discredited as an observation, yes, that
My lords.
we are giving you liberty to ask for recalling of those observations.
My lords, that I'm most grateful, but if I may most respectfully submit, if my lords may consider I'm only aggrieved by paragraph 45 and 47. The merits of the matter, I'm keeping it aside. I'm not.
44, you are only concerned with 44 and 47.
My lords, in fact, I must say.
Go to the High Court, explain your conduct. Maybe that you partly will succeed there. And in case you are still aggrieved, then come to us.
My lords may permit me that.
Learned counsel for the petitioner submits that she may permit you to withdraw the special petition with regard to move an appropriate application before the High Court. And
First appeal number 704.
in first appeal number 02 of 2025, decided wide impugned judgment dated 24th February 2026. For such an application, the petitioner wishes to seek recall of the adverse observation, stop expansion of adverse remarks recorded against him in para 44 and 47 of the impugned judgment.
Great.
So, the specially petitioner accordingly dismissed as withdrawn with liberty of mention.
My lords is also giving me liberty to come again in case I'm aggrieved by the order.
Liberty is granted to the petitioner to approach the court again, if so required.
I'm most grateful, my lords. And I really didn't mean to defend the order.
Little bit, that line, probably High Court has gone excessively in saying that it's a case of doubtful integrity.
An extraneous.
That inference should not be drawn by the High Court.
In fact, my lords, I really.
Dishonesty is an incorrect finding.
It's a case of gross negligence,
Lack of
judicial. It could be, but not a case of where the High Court should say that because of this reason your integrity is doubtful. There we don't appreciate, but you follow the procedure because nothing can be done in peace.
District judge does not know the consequence of a decree passed against a dead person. It's very, very deplorable.
My lords, the only thing was that he wasn't.
Don't defend that. That won't improve your case.
I'm grateful to my lords for the order that has been.
Sometimes what will be the more practical way is tell the High Court, there is a mistake on my part. I don't have any explanation. I filed. Probably any judge will feel that you are coming with honest intention. They will.
I'm most grateful, my lords.
I'm praying for some more time because guidelines to be.
Lordships, this is the comedian's matter.
I know.
So your lordships, in the last order.
Is there any follow-up observation about their conduct?
We don't have.
These youngsters, they promised us that they will now be our rather social engineers and they will work hard. They must have done it. We have no reason to doubt. They must have done some commendable job.
They have filed an affidavit, your lordships, saying that they have
of compliance of para 4 also, Madam Apradita.
Yes, Your Lordships. What they have said is that they have organized a few events with disabled persons, but they don't have our addresses, they don't have our contact details, so they could not contact us. So this is the first affidavit. The second affidavit, which has been filed yesterday, it's the same order. So they have not contacted us, and I really, if they don't want to contact us, if they don't want to interview us, as your lordships had suggested, that it would set an example for the rest of the people who are suffering from such debilitating disease, that is up to him, lordships, because your lordships had left the choice to him to try and persuade us. This gentleman is in no mood to persuade us. He has done his own things. So we are just not, we don't want anything from this gentleman because something was done in very poor taste. I did not ask for any penalty against him, your
No,
lordship.
ma'am, it's not a question whether you want it or not. It was required of him.
But your lordships
Yes.
suggested that you should invite them and do it on YouTube or a program. He has done some programs in some on physical locations.
And second, his use of expression disabled person is wrong. It's specially abled person.
Exactly.
That's how our country uses the name. We never say disabled persons. We always say specially abled.
Mr. Chandrachud, who has been representing them?
39. That was in the other matter, your Allahabadi matter, I think that.
Number 6, Samay Rana, I am appearing yours. Please. I am appearing for responding 6 yours. We have complied with the order, Milords. We have certainly we have said that we'd like to approach them. Milords, we will because of the program, we are again going to, because it's a monthly, Milords have given us a direction. In the next following months, Milords, I assure that we will approach them, we will tweet them, we will some.
I'm sorry by this tone, lordships, they are not obliging anybody. It was your lordship's order.
If you
They
have that arrogance,
comply
then don't
with
do it.
They
Don't
are
do it. There is
it's a
not
favor. And on affidavit to say that they don't have the contact details, the lawyer knew me, the lawyer was contacting me. They could, last time Mr. Radheshwar Singh was here. And in fact, I said that I'm not looking for any monetary compensation. And your lordships insisted.
No, you have been right from the very beginning saying that you don't want even a penny.
Exactly, your lordships.
It is only we thought that they will show some repentance.
I didn't want to say this, but initially, recently, he started one show. There he kind of mocked the system without naming anyone, of course, Manoj. It can pass on as a fair sarcasm or something. He stated that now at the beginning, I am doing something which I did not do on the last, what is called series. And he hangs the limbu and mirchi. That I didn't start with that earlier. Now I am doing it with that. He didn't name anyone, but it was quite not visible, quite demonstrative what he is hinting at.
And lordship,
but I didn't want to go into it. But if he has not even contacted them, then this is not a lapse, this is arrogance.
And lordships, with utmost respect, I can say now we find it distasteful to go for his show because this is the lack of respect. There is no genuine apology. He's just going through the motions, inviting some people at a physical location and doing it. We didn't ask for it, but your lordships told us that, you should engage, and we did it. And this is the way he's treating people who are already suffering so much in life. I don't know what kind of icon he is for the youth.
You are talking about this Rana.
Samay Rana, lordships and icons who are presenting this.
No, our youth has better icons. Sometimes we ourselves give those titles to that I am a youth icon.
They are self-styled. They are like
self-styled.
They are
self-styled icons.
So many gurus and so many nowadays this
influencers. You're not correct. And they genuinely believe that they are influencing.
Say something.
You tell us after the last order, what have you done?
We have conducted show with especially able people.
Where is the affidavit file?
Compliance affidavit. For these 3 months we have filed. Even the latest affidavit we have filed, the compliance.
Where is that affidavit?
One affidavit was filed.
Do we have?
No, after 27th November, after 24th April, where is the affidavit?
I am receiving just now. When was this?
We can get document that, bro. They're doing so.
No, must be. That's
Because yesterday, the latest affidavit we could file only yesterday, because probably it is not before my lords. We have served the copies to the.
It was given to us last night, so I'm sure it's not before this one.
I'm sorry for delay.
say one of the say we have heard and for the parties briefly. We have no reason to doubt that one of the respondent क्या नाम इसका रहना वहना क्या है
समय रहना
उसका लिखो that he has taken not only taken the court for a ride, he is in brazen violation of the statements and undertaking stock statement given before this court. The misconduct is sought to be further compounded by making a false statement that an affidavit of compliance was filed yesterday, whereas no such affidavit is on record. Also, subject to the cost of this 10 lakh, it will be deposited with the registry of this court within 2 weeks. 2 weeks time, 15 days time is granted to file the compliance affidavit. So it is made clear that if the cost is not deposited, pursuant action shall be taken against the person in default. Who is the other fellow and what is their conduct?
Lordships, there were 4 of them.
Your Lordship, I'm appearing for respond number 7 to 10. We had filed the affidavit in January. Your Lordship may have the affidavit. It was filed on 28th January 2026. This is respondent number 7. Vipul Goyal. If your Lordship will have the affidavit.
Where is that affidavit?
Your Lordship, it was filed, it's on record, it was filed on 28th January 2020.
After January, we are in July.
Your Lordship, we have filed the earlier affidavit also. These are the, I'm
Why we should
carrying
take
the hard
affidavit
copies
like-
also.
Why affidavit in court? फेंको इसको। नहीं लेना है। It is not the way to file affidavits.
Your Lordship, this one is on record, the January one. After that, the affidavits which have been filed, these are on record. There's only one affidavit which has been filed yesterday, which is not on
last
record.
Affidavit on record.
Your Lordship, we first have this affidavit of January 2026. I'll just
see that affidavit, which is the last affidavit on record. इनको सबके 5 lakh cost each within 2 weeks and then 15 days time.
Your Lordship,
And
may I
then
just show
wait
the
for the next order.
Your Lordship, may I just show the photos from the affidavit of January that we had invited.
We are not interested in photos. We are interested in action.
So the photos would show that we had invited all the differently able people.
If you don't know you to mend your ways and you don't know how to respect the court order and how to respect the sentiments of the other very respectable sections of the society, then you must face the consequences.
Miloj, may I please submit something? Miloj, we appear for IPF, sir, for respondent number 7 to 10. Miloj, about rupees 9,61,000 have been raised every month. These two shows are being organized, Miloj, and we've been filing affidavits. Only for the last one, Miloj, this affidavit was filed after the quotas, therefore it could not come on time.
You have not filed any affidavit after January.
I'll just check on that, Miloj. But 9 lakhs.
Check up. You don't know your own filing?
Miloj,
In the meantime, if I may,
9,61,000 Miloj has been raised and my lords, about 2 lakhs was deposited with the petitioner my lords organization.
There, nobody is begging before you for the 9 lakh or something.
Intention, my lords. We are just
9 lakh
taking
rupees,
your
yeah.
lordship's direction, my lords, for the remaining 7 lakhs rupees, that is, my lords, that was raised, my lords. We're just seeking your lordship's direction, my lords, if we can deposit it.
Now you add.
No, Lordship, we don't want their money,
They
Lordship.
don't want a single penny.
We don't want any.
You add, you deposit this amount with the registry. We will release that amount to the poorest sections of the society for fighting their lawful rights and for their pre-legal aid.
Please, my lords. May I just request if your lordships to just have the last affidavit for a moment. I please beg your lordships to consider my affidavit.
Did you invite Mr. Singh's clients to your show?
My lords, not the clients, but people suffering from.
We are not on that.
This is an ego trip, your Lordship. This is an ego trip.
The ego problem.
This is ego problem. This is arrogance.
One second. Our order was very clear.
Yes, my lords.
We said that, and in fact, on your prayer, because this is recorded, they also seek permission from this court to invite the individuals whose brief details have been brought on record by Ms. Singh. So before us, you say that we would like to invite Ms. Singh's clients and express our genuine remorse for the feelings which have been unfairly treated, their treatment. Now, you make this impression before this court, we record this, then you get some special individuals, you have your show, you get some money, and you said that we want to deposit in their organization. Isn't it it gives them a sense as if you are trying to buy them out?
No, that is not at all, my lord, the intention. I'm so sorry if that.
Then you should have, your conduct should have been.
If the visibility, if their visibility was something which you had used as your fundamental right to commercial speech, then at least their fundamental right of dignity should be similarly demonstrated through your program, that there has been a switch.
Only your fundamental rights are the only written in the Indian Constitution. What about their fundamental rights to dignity, to a dignified life?
Milords, we bow down to that, Milords. And in fact, Milords, we would still like to demonstrate, Milords, our conduct. If
No, your conduct you wanted to demonstrate in November 25. Then conveniently the conduct shifted to other convenient individuals and not the individuals who had brought you to court.
Of January, your lordships, I have attached photographs. If for a moment your lordships may please.
Now comply with this today's order, then we will see whatever you have to do.
Milords, every month 2 shows, Milords, are being organized as per your lordship's preference, Milords. May I please request?
They have still not understood your Lordship's order.
Difficulty is, sir, you see everything from the commercial lens.
Exactly.
Right? You have forgotten that after all your shows deal with sentiments, your shows deal with humor, right? And humor is perhaps the most core and this precious value that every individual had to a right to happiness. And that is what you have lost because of your persuasion of right to material wealth. You're welcome. We welcome that.
In fact,
nothing against that and your right to commercial speech. But before this court, you give this impression that these persons have been hurt inadvertently. We will bring them on our show and we will also try to assuage their feelings in public. And that is exactly what the very idea of truth and reconciliation is all about.
Exactly.
That you have a truth and reconciliation. Yes, I made a mistake. I admit it. I reconcile it. The manner in which I made the mistake. That's not there. What you do, you want to buy out your way from judicial complexity.
We're very sorry, Milords, if the impression, impression, Milords, is great.
As an artist, you lead a public life.
Yes, Milords.
And in public life, always remember, respect is an investment.
Yes, Milords.
More you respect the others, you earn for yourself. Instead of that, you start humiliating the others. You want to popularize yourself, you want to commercialize yourself, you want to capitalize yourself. by insulting, humiliating, degrading the other. When we make you to realize the mistake, you say, yes, yes, I do understand, I should not have done it. I now, with a view to express my remorse, I will do like that.
Lordships, it's fashionable for them to denigrate
You are
people.
befooling the court also.
No, no, Milords.
Then?
Milords, we agree, Milords, mistakes have been made, Milords. This was a learning lesson for all of us, Milords.
As Lordships, I'm sorry. Last time I was the one insisting that your Lordships, we don't want any penal consequences.
Right.
But,
Right. Not
but
only last
today,
time, from the very beginning, she said, we are fighting for dignity, not
Yes,
for money.
not for
a single penny they refused.
and Lordship, we didn't take the penal route also. We didn't file any criminal case against that. But here the problem is they come and say something in court and they do just the opposite and then try to say that we could not get their number. I mean, and Lordships, these are accomplished. In fact, your Lordships observed last time, these are accomplished individuals. Somebody is working in Microsoft. This is an organization of mothers who are bringing up their child with all the adversity they are facing. It would have enhanced their show. They would have got, even if because they only believe in market and audience, so they don't even have the commercial sense to understand that this would have enhanced their show. But this arrogance that I'm not going to bow down, this is what's driving this whole matter.
Your Lordship, may I just make one statement as a court officer and as not really lawyers of respond number 7 to 10. What I am given to understand is that the people with especially able people were called and the photos have been put on record before this court. However, if there is some, I don't know the reason, but my learned friend, if she's saying that they have not been reached out, it's very unfortunate. And we'll, as court officers, prevail upon our clients to ensure that.
I'm not saying your affidavit says.
Prevail upon anyone.
Counsel.
No,
we can't do anything. When we are saying, me or my brother, or my sister, we are expressing our anguish, it is not against the counsel. Please don't misunderstand.
Absolutely not, Your Lordship. I am
upon the client to comply with court's order. They are bound to.
Your Lordship, all I am saying is that if for some reason, Your Lordship, I don't know today what is the reason, but if for some reason, as my learned friend is saying, that that those people were not reached out, then it is extremely unfortunate. And I will ensure that as a lawyer, as a court officer, both, that my client will do the needful. He does not have an option. He has to comply. The only thing is that.
Not a respectful action.
Absolutely, absolutely.
You are not obliging anyone because this is a compulsion now.
I bow down before Your Lordship.
Therefore, you have invited today's order only despite last so many hearings. We have been liberating you, we have been granting liberties, we have been showing extraordinary magnanimity, and we thought that you are very youngsters belonging to very respectable families. We have respect sentiments for your family members, your parents, and everyone. We thought that you will also realize this.
Your Lordship, all I can
understand the others' predicament. And we'll do something.
Absolutely. Your Lordship, I follow. All I am saying is that it has not happened out of ego. They said that they did not have the information to reach out to the other person, and that's the only reason. If they would have reached out to me as a counsel, I would have ensured that they would get the information.
So under the wrong impression that you don't reach out to them, you run out from the court. And they think that while sitting outside the jurisdiction of this country, as if they are exempted from everything.
I follow, Your Lordship. It's just a lackadaisical approach, which is not appropriate.
Arrogance. It is not lackadaisical.
It's not arrogance. Your Lordship may take it. It's not arrogance at all.
Shows their attitude towards the court. They have no respect for the institution. They have no respect for the victims. And to say that they in the affidavit, they say that we don't have their contact number. And then for the counsel to argue that, no, he was trying to contact, I don't know what kind of argument is that, Your Lordships. And I have never gone aggressive against.
What have been done is to contact the learned senior assisting counsel, advocate on record. They in half a minute they will give you the number.
We all meet each other every day.
Milords,
now let them suffer for some.
Milords, I am genuinely apologizing on their behalf. Milords, we will try to make amends. Milords, that's but there was no arrogance, and in any case, Milords,
if this is not arrogance, then I think we have to change Oxford Dictionary also.
Milos, I'm really sorry, Milos, if it has come to this, Milos, we will, in fact, Milos, I'll personally contact my learned friend and I personally go to her office to get the numbers, Milos, and I assure Milos.
ये सबका common कर दो 5 lakh each.
Obliged.
Estimation from our side.
Obliged.
Lordship, for seven.
Only to end on a happy note. Lord, 15 days back, I was in Ahmedabad. Lord, there was a book release function of a humorist who is, Lord, writing humor since 55 years without using politics, politicians, or any vulgarity. So I just generally said that it is really amazing that in the era where there are stand-up comedians and reels and multiplicity of humor, you are still surviving since 55 years. And his answer was really enlightening. He said, Tushar, I am a humorist. The humor is always perennial. Comedy is always transient. I am a humorist, not a comedian.
Learned SG himself has written a book on court humor. And
No, that's another thing. But it's very difficult to survive without vulgarity or without involving politics.
This transience is what is the right answer.
Yes.
Lordship, one last submission is that considering all differently able people were called for and those photos have been placed on record, if the cost may not be imposed because it is not out of ego or arrogance, because there is no place for that for us.
Cost will have to be imposed. Cost is because of the non-compliance of the court order.
Your Lordship.
Affidavit of compliance filed, nothing is done last 3 days because they think that now Supreme Court might have forgotten. They don't know how the courts are unpredictable.
Your Lordship, that's not the intention.
One hearing, if you are extreme lenient, one should encash that opportunity.
Absolutely.
We gave the opportunity. Unfortunately, your check has bounced. There is nothing like encashment and bounce back.
Your Lordship, we have filed the affidavit. It's just that it was not filed on time. Yes, but it has been filed. We have the diary number. It's not on record, but we are carrying the prints.
हो गया बस 3 लाख पर सब कर दीजिए हो गया डिस्काउंट now up within 2 weeks file affidavit, otherwise we will add 1 0 simply next time.
Lordships, there was another request that which we had made and your Lordships had passed an order that these are the persons with spinal muscular disorder and it falls in the category of rare disease. So your Lordships in your order has directed that the union may consider, because on an average, each person requires 55 lakhs annually for treatment. So we had requested your Lordships and your Lordships had directed the union to assign some amount from the CSR funds to these individuals because
probably the suggestion was to create a corpus item.
Yes, your Lordship.
So there is a petition, separate petition pending on that issue. My colleague Manod is appearing in, he would be more conversant with because this is an issue. Small children, sometimes Manod, they need medical expenditure of say 16 crores in a year or something. So what to do?
That's a one-time dose. Lordships, that's a preventive dose.
It's a rare disease.
It's a rare disease.
Yes.
There is something being worked out.
Lordships, the 16 crore is that, in fact, this is the genesis of the matter where he made fun of that if a child is given a vaccination which is worth 16 crores before the child crosses 6 months, then this disease can be arrested at that very stage. So that's a one-time vaccination. So that's a separate issue which the learned SG is talking about. But this, apart from that if you are actually in the disease, it's every year around 50 lakhs, which the parents, the mothers, they are trying to, Lordships, in any which way possible, they're trying to arrange funds. There are some hospitals who give them free service. So I'm just requesting the learned SG's office, if he could use his good office.
I cannot understand the problem sometimes for people with and even people with good income also. 55 lakhs in a year, you reach a choice where either you spend money or you give up hope for your child. It's a very, very difficult situation. I believe something is happening. I'll talk to my colleague.
Because
I will find.
we said that diverting government funds will not be easy. Reason is because then state will have to act in a non-discriminatory manner for every kind of, for every
Correct,
disease.
correct.
State can't say for this particular we can provide fund, but this we will not be able to provide. So we thought that there let it be some donations, some genuine persons who are in a position to help, and then they can create, if the corpus is created, some running in, interest part, and then it can address the issue. So just examine from this.
I shall do that. I shall.
Then next, after 2 weeks, then we are taking up. On that day, we will consider.
I'm grateful, Your Lordship.
Your Lordship, just one last submission for your consideration. The affidavit which I filed in January of 2026, it would just a fair submission in that I had recorded specifically that I don't have the details of the petitioner. So if the petitioner can provide me the details, this affidavit was served upon the petitioner in January. She's read this affidavit.
Difficult to get details. So you are
I'm just
compounding your problem.
When you say like,
In fact, that's the problem.
in this line.
The more you speak, the more the subterfuge comes out.
Lordship, I'll bow down.
Lordship, may I finally say what an honor it is to appear before my learned colleague.
We'll take up after 2 weeks now.
Please, Your Lordship. Obliged, Your Lordship.
Item 40.
No, this is that acid attack victim, my lords. Lord, now the desired amendment, my lords, and copies. But main section already had this, my lord, that not only just facial disfiguration, but internal also. That was
16 lakh probably something.
yes. Schedule, my lord. In the schedule, it was missing. Now we have amended the schedule, my lord. In your lordships have the second page, my lord. Second para in the schedule to the said act under the heading physical disability under subheading a locomotor disability for serial number E and the entries relating thereto, the following serial number and entries shall be substituted. Acid attack victim means a person disfigured externally or internally due to violent assault or self-infliction of accident by throwing, administering, spilling of acid or similar corrosive substance. So external as well as internal.
Or internally.
That was the concern.
Have you examined this notification? Dr. Kaur, have you examined this notification?
The petitioner will examine it as well, Manoj. We'll examine it as well, Manoj. We have to get it.
One petitioner in person used to appear, Manoj.
The main petitioner is I appear.
Shaheen Malik used
to appear today. We are here for her, and also Mr. Swarkripal sir is also appeared for the petitioner.
I appear on this matter. Of course, the amendment has been seen. We will examine it. Our only clarification that we asked the government, and they may clarify, is as to whether this amendment would have retrospective effect as well. Because we are concerned that if there is an amendment that is brought in, it should cover also those people who have unfortunately suffered in the past. So if the learned solicitor...
it's a clarificatory in nature, therefore it will have to have...
That's a clarificatory amendment, so it will apply
to have retrospective
of the original notification. That we will clarify.
Please, clarify. There are two other IAs as well.
One to the previous order, learned solicitor of India has placed on the court a government notification, dated 22nd May 2026, issued by the Union of India Ministry of Social Justice and Empowerment, in bracket Department of Empowerment of Persons with Disabilities, whereby the schedule to the Rights of Persons and with Disabilities Act 2016, under the heading inverted commas 1, serial number 1, physical inverted commas closed, under the subheading again inverted commas 3, locomotor
इसीलिए लगातार लग रहे हैं ना, ठीक से वो भेज दिया है ना, भेज दिया।
Where under the heading number so and so under so and so has been amended, and clause E and serial number E shall serial number E shall now serial number E as amended reads as follows. Next paragraph. Since the above stated notification amendment is clarificatory in nature, it shall be deemed to be in existence with effect from the date the Rights of Persons with Disabilities Act 2016 came into force. The necessary consequences shall follow. With respect to the other issues, post the matter.
I have submitted the chart, except Gujarat, SLS and Gujarat High Court. All the state governments have given their response. I am submitting the chart. There's one more thing also. For under the Poison Act, many state governments have not issued the rules for regulating the sale of the asset. So Lordship asked the state governments to come up with their proposal.
As
They
regards
have issued and will there.
as regards the sale of the
regulation part may also
asset,
be.
there is an application. Sorry, I don't. There's an application that is pending.
High Court Gujarat and SLS also, madam.
There's one issue with that. My lord will hear it whenever my lord has the
Lordship,
time.
if I may submit,
Even though
Mr.
certain
Saurabh
states
was trying to
have
speak
filed-
and he is not on.
Today we are only.
We have twofold submissions to make.
Not today. We'll
Give another time.
Because today we just want
We'll address my
amendment
lords.
to clarify that this will apply.
Because the only issue will be as to
One
intervention. This amendment
Just
that
one
we'll deal on the next day.
My Lordship, there is an IA that we have filed and we're along with it.
You just, have you got a copy of the notification?
Yeah, we already have it.
Go through notification. There's an intervention application because we are one of the foundations. We're at the forefront of rehabilitation of these acidic survivors and being in close touch with them, having worked with them on field.
We would like to seek your assistance.
Please, ma'am.
Your application for intervention allowed.
Please.
The foundation is permitted to assist the court. The foundation may submit a proposal with respect to the actions that may be required. That may require judicial intervention by this team. You submit a comprehensive proposal.
Just one request. There is an IA that we have filed asking for the operationalization of the disability certificates. So now that the amendment has been carried out, the problem is that the regulations which allow for disability recognition as a certificate are only structured on what is the external disfigurement. So the union will also have to now come up with guidelines as to how to classify a disability and the percentage of disability after ingestion of the acid. So according to that guidelines, a disability certificate will then be given, because as of now there are no rules. So if the solicitor could look into this issue as well, so that in the absence of a certificate,
It's going on. We are in the
process.
Submit a proposal, small proposal, small note on it. Then we will take further.
I will do from the next one.
Whatever directions are required, we will do that.
Well, it's the assessment guidelines are 2024, and we are already now, well, it's after the amendment, we are also looking after those.
Now, you will also follow up.
We will do that.
Obviously, because follow-up action will have to be there.
Has to change, Malad.
Meanwhile, you can also examine and submit it.
Yes, we are in the process.
Thank you.
Much grateful, Malad.
Item 41.
There was a cartoon, etc. We are in touch with her Ladyship Justice Indu Malhotra, who chaired the earlier committee, and Justice Aniruddh Bose, as a chairman of the Judicial Academy, and we are amending it. We have filed an affidavit. It's not on record, but it's on record.
That's on behalf of
Do we take it after 4 weeks or
Yes.
6 weeks?
By that time, it would be
After 6
new.
weeks, we'll take it.
That's, if I may, with the deepest of respect. With respect to the academics, we wish to move an application on para 5 of the last order. It will be a very limited clarification that we seek, because both government parties and private parties have refused to engage with us despite the clarification. So if my lords could just help us in that particular kind of confusion, because government parties as well as private parties are refusing to engage with us despite the clarification. That's the only reason. We'll move an application in that regard.
We file an application.
We'll do that. We'll do that.
Now, Victoria Basu, matter 43.
We filed a status report on behalf of MEA. I had a meeting with the senior prosecutor of the prosecution matters, and we have, after that, I've followed up. This was just last week, Manas, and we have requested their cooperation in terms of your lordship's March order that for now, we are, Manas, seeing that there can be some interaction. Father was also writing some mails, which we've requested him not.
Here, he is present here.
Yes, so I've requested him not to write mails because we are seeking some cooperation. So Manoj, that may agitate. He is also.
You will get nothing if you keep on writing.
He's agreed, Manoj. He has agreed. So there is some positive development. Your lodges, nothing to show to your lodges, but we are making efforts. That is what the status report shows, Manoj. We filed it on behalf of MEA.
We are grateful towards Ms. Martin.
I have got copies, Manoj. We filed it yesterday. It may not, your lodges may not have had.
If you, some fresh status report has been filed by Union of India, by NCT of Delhi or Union? By the Minister of External Affairs, the same is taken on record. Post the matter for further consideration. Meanwhile, you continue with your efforts. Because passing order also will create problems. So that's why we don't want to say anything.
Maybe only request that the next date is after 4 weeks, Milord, on a fixed date. On a fixed date after 4 weeks.
Your lordship's court always gives a fixed date, Manoj. Great.
Now, rest of the matters, where is the item 54 and
54 and 56?
Item 44, Milord.
Only a minute.
Item 44 is.
No, item 40.
The Lordship have especially fixed this matter for today, Milord. Item 44.
Just a minute, 54 and
54 and 56, my lord. I am appearing for the state of West Bengal. Our SLPs are there. It concerns, my lord, OBC reservation. The cabinet has decided to withdraw the SLP. If anybody else has any grievance against that judgment, they can file separate.
Lordship, there is another SLP by the commission which is not listed. That also I am praying for withdrawal. I'll give the number.
Just one aspect. On the withdrawal, on this withdrawal only, we are the impacted parties.
That the state does not want to pursue the special petition. The same are accordingly dismissed as withdrawn. And your is by?
I'm by West Bengal Commission for backward class.
So in this very matter or another matter?
Same impugned order. We also have SLP in the batch. It has not been listed.
No, there is one more.
That is not listed. West Bengal Publishing Commission. SLP number so and so is also taken on board, and the same is also dismissed.
No, there are
this policy, 54, 56. Just allow me one second.
Allowed.
Impacted.
All of the state does not stay.
There are in time now. Because we'll be hit by time. We'll be hit by limit.
Item 44, your lordship, especially fixed for today, Milord. It's a custody matter, Milord. Item 44.
Item 44 may either any willingness.
Milord, it was to be verified.
There are two more
matters. In item 44, the sureties was to be verified and filed the affidavit, Milord. Yesterday, I have received this affidavit from the state, Milord.
Are you filing so affidavit? Like affidavit taken on record on Friday.
There are two SLPs which are not on board. But I'll give the number, same impugn order. I'll give the number that may be taken on board and not.
Milord, this matter will be taken. Item 44 may be taken.
Lordship, item 51, I have filed an IA regarding it.
Item 44 may be taken up on Monday if your lordship. It's a custody, my lord.
We thought you are insisting for Friday, Monday. This month, coming Monday or next Monday?
No, this coming Monday.
After so you want 3-4 Mondays, we can take it.
No.
Lordship, item number 55.
Lords, item 47.
Just
one aspect.
55 also dismissed withdrawn.
Noting liberty also.
50 with 54 and 56 having been dismissed.
55.
We are impacted by the till now the state was prosecuted.
No liberty is taken away by anyone, my lord.
Plus otherwise we'll have to come. He doesn't have objection. The solicitor is saying anybody else can challenge. He said that fairly.
No, but
that not mine. 54 and 56. I need liberty to challenge. I have moved.
There is no liberty taken away.
Because
Otherwise, my lord, I'll be hit by limitation. The order is 1.5 years old.
The order of withdrawal will not preclude the.
That's all.
The other affected persons.
I'm so great.
Item 47, my lords.
In accordance with it.
Item 47, short issue.
55, my lords, I have only prayed for liberty, my lords, that
Item 55 issues are withdrawn. I allow.
with liberty, my lords, with liberty.
Lords, item number 47.
Avail the Vivad Se Vishwas scheme, my lords. Because I prayed for liberty to avail the Vivad Se Vishwas scheme, my lords, that was